May I please elaborate,
Yes,
sir?
Ms. Devi.
I beg to mention item 5, my lord.
Yes.
After Bihu vacation, my lord, because writ appeal is pending. Series of cases are pending, my lord.
Now, why should we keep this pending also? Let it be disposed of.
No, my lord. Then I have to file writ appeal again. Since the writ appeal is pending, similarly
Okay, right.
situated person.
On the prayer made by Ms. K. Devi, list the matter in May.
I'll
May,
oblige.
give a date. The petitioner's case is that a similar matter has been, that the present case is a covered case, wherein the writ petition was dismissed. However,
Yes.
the WA number
Writ appeal number 171/2023.
171/2023
Which
is
is
pending before the division bench.
Yes.
That's all.
I'll oblige.
May please, Lordship. Lordship, I beg to mention items 7 and 8. Lordship, I have taken the consent of the Department of Plain Tribes and Backward, as they are the main contesting respondent. This matter may come up after 3 weeks, Your Lordship.
Why? What is this? You see, this is basically the caste certificate. It has to be decided by them. Let them decide. Why should we keep it pending?
This matter
Whatever
is,
decision comes out from that SLSC, that will have to be either accepted or put to challenge. That's all.
it is already pending because that has been put to challenge. So Your Lordship may tag it with another writ petition, WPC.
No. My question is, why should I keep it pending?
Because
There's nothing to be decided by this court.
no, this interim order has been protecting me because my admission is going. I'm studying because
We'll say that the interim order will continue till the SLC decide.
the SLC has decided that has been SL in the writ petition 825 of 2025. So Your Lordship,
Acha,
824 of 2025.
824 of 20. This is the same petitioner.
Same petition.
Then, so this writ petition has become infructuous.
This writ petition will tag with that one
This writ petition has become infructuous.
because Your
If
Lordship,
you're challenging the SLSC decision, which is to what effect? It has upheld the cancellation.
appeal the cancellation, but it's totally Your Lordship. will
Whatever
see-
it is.
Yes.
So this matter has become infructuous.
No, Lordship, because
You wait, we'll see. You wait.
May I please, sir? My lord, I recommend for listing withdrawal matter, my lord.
Okay.
Oblige.
Yes, madam.
My lord, I beg to mention item number 10, my lord. The
Yes,
10, my lord. The matter is infectious, my lord.
infructuous. Okay, miss.
My lord, the petitioner has already got the provisional.
Your name, madam?
N. Nasrin, my lord.
Miss N. Nasreen, learned counsel for the petitioner, submits that the matter has become infructuous in as much as the petitioner has been given pension,
Provisional pension.
provisional pension. Accordingly, on the prayer of the petitioner's counsel, the writ petition is closed as infructuous. But what about regular pension? Has it been given?
My lord, it has not been given. Our petition only for provisional.
Okay, only for provision.
Oblige.
May I please, Your Lordship? Lordship, I beg to mention item number 9, my lord.
Yes.
I want to withdraw this writ
Okay,
petition.
Mr.
H.L. Ashkaman.
H.A. Laskar, learned counsel for the petitioner, prays that he may be allowed to withdraw the writ petition. The prayer of the petitioner's counsel is allowed. Writ petition dismissed as withdrawn.
Most obliged.
May I please, Lordship, Lordship, with consent of other side, Lordship, I beg to mention item number 27, Lordship. Lordship, in this case, Lordship, we are going to file Mukalatnama, Lordship. As Lordship, the former engaged counsel has already withdrawn from this case, Lordship. So 2 weeks' time may be granted, Lordship, otherwise.
Mr.
V.U. Laskar. Fine.
B.U. Laskar,
Yes, Lordship.
learned counsel, submit that he will be appearing for the petitioners
Yes, Lordship.
and will be filing Wakalatnama within
Lordship, within 2 weeks,
within 2 weeks. List the matter after the vacation.
may I please, Your Lordship? Lordship, in item number 39, Lordship, we have filed additional affidavit, but it is not on record, Lordship, and the record may be called upon. Obliged.
May I please, Your Lordship, I beg to mention for listing a matter for withdrawal, Lordship, tomorrow. Begs to mention for listing of an IA for tomorrow. The IA will,
New IA,
Lordship, pending all Lordship.
go to the registry.
Lordship, we have filed it today, Lordship.
Oh, you filed it today.
Lordship, this matter pertains to this online admission portal, that one, Lordship.
Tomorrow is
When?
the last day.
When do you want?
Tomorrow, Lordship.
What is the filing number?
Number, Lordship. Fine, I'll take it.
You have not filed it. If you had filed it, you would have the filing number with you.
Lordship, there is urgency, Lordship, tomorrow.
Huh?
Tomorrow, Lordship, is the last day.
Mr. Council, please file it first.
Huh.
You see, you file it first.
Lordship.
May I please your,
Yes,
may I please your lordship, my prayer is for listing writ petition lordship regarding compassionate appointment challenging the office memorandum, all pending matter, 24 matter,
tomorrow.
6 matters lordship total.
May I please, your lordship, I beg to mention for withdrawal.
Okay, tomorrow.
Your lordship, I beg to mention item number 14.
14,
Yes,
1/4.
yes.
Yes, what about it?
My lord, the petitioner, we have no updated instruction from the petitioner, so we need some time.
Huh?
We don't have any update
So,
instructions from the petitioner.
so,
We need some time.
no, nothing doing. You tell your senior to come. You're challenging the departmental proceedings, correct? Tell the senior to come.
May I please, your lordship. My lord, I'm praying for listing one matter. Fact is that we have challenged the proposed shifting of an LP school, lordship.
When did you file?
Lordship, we filed in the month of December, lordship.
Go to the registry. Okay.
So may I pray for taking up this matter immediately after vacation?
Huh?
We are awaiting instruction.
Wait, why is basically why they mentioning here? So just see, if it basically matter, you said that you would tell them to maintain before the concern letter. Yes,
Well, here I'm awaiting instruction. Madam. Let this matter come up after.
there is stay order.
Yes, there is an interim order.
This matter is pending for quite some time. Why should we issue notice on?
Bilateral issue, no.
Heard Mr. S. Bhattakur, learned counsel for the petition, who submits that the petitioner has been temporarily deployed to the Bothopuri Bodo Higher Secondary School. Though he is a teacher, he is a postgraduate teacher in Dispur Government Higher Secondary School. This issue notice returnable in 3 weeks. Mr. B. Kaushik accepts notice on behalf of
All the respondents.
all that's one. Mr. B. Kaushik shall obtain instructions as to why the petitioner has been temporarily deployed to another school.
Madam.
This is the matter of the
Interim orders.
interim order to continue till final disposal of the, no, don't say that, till the name. Yes,
Lordship, compassionate appointments.
compassionate appointment. Have you got a compassionate appointment order? Huh? No, the ones that we disposed of in person. Heard, Mr.
H.L. Ashkar, madam.
H.A. Laskar, learned counsel for the petition. No, acha. But in item 2, you're not there.
Lordship, in Ukalatnama, my name is there, my
Okay.
lord.
I heard Mr. H.A. Laskar, learned counsel for the petition. Also heard Mr.
Yes,
S. Das for
1 and 2, madam.
1 and 2, and Mr. G. Pegu for 3 and 4. 3 and 4. And as per the order, okay?
But this case has been different, my lord.
Why?
Because recommended by DLC, but whether it was placed before the SLC or not, that to that effect.
Doesn't matter. So if it's recommended by the SSC, SSC has to take a decision.
Yeah.
If decision is taken, then you give him a copy.
Fine.
If decision not given,
Minor.
nah.
Item 3 also
Same
similar,
order.
similar, and item 42 also similar. my lord.
Just a minute. Item 42 also. Okay, huh?
My item 55 also similar.
55?
55.
There is no.
50. 45.
Wait, Mr. K. Majumdar, 45, huh? And out here, who is the same? Then who else?
45 too.
No, 45. Then next, that's all. 43, Mr. A. Boro, huh? 43. And then,
44, 46 and 47.
huh?
44, 46 and 47, my lord.
46,
44, 46,
no, 46, 47, I'm dismissing.
44, my lord. also.
That's a nice try. What happened to the review?
Review of file, my lord, that is to be
And
decided.
no, what is the review case number? Tell me.
Review, my lord, filing number we have got, my lord. Filing
In,
number, my lord, in, my lord,
in which one? In item 46?
my lord, item, in all the three cases we filed review, my lord. 44 is, my lord.
Huh.
44 is review with the serial number 4354/25.
Just a 4, 3,
54
5, 4,
25.
25.
Then, my lord, 46. 46 is, my lord, 4338/25.
4, 3, 3,
8,
8 of
25.
25 and
And, my lord, 47 is, my lord, 4353/25.
4, 3, 5, 3 of 25.
25, my lord. This serial
So
number.
these 44, 46, 47, I'm dismissing. No case. 40, 44, 46, 47, dismiss. Mr. M. Data appears for the petitioner. Who appears for the other side? Mr. Kaushik. In 44, 46, 47, who is appearing? Elementary. Mr. B. Kaushik appears for the elementary education department. I'm dismissing 44, 46, 47.
My lord. Apply, your lordship.
Government advocate Mr. Pegu. G. Pegu appears for the state government. Oh, I do not know. Let them come. That is different. Acha, wait, this is the matter. No, I don't want this. I want the orders passed subsequent to this. There is orders passed subsequent. Item 4.
Your lordship, wrong fixation of.
Okay, we'll issue
gateway.
notice. We'll issue notice.
It can be,
Can be what? Can be disposed of?
yes,
How?
it will be calculated, it's a wrong entry. Your lordship may kindly for a moment see the revision of pay rules, annexure 5, page 49, your lordship.
Yes,
Page 49, relevant is page 50,
page 50.
50.
Yes,
The pay structure table, your lordship, table 1.
yes.
Pay band is correct. Existing GP means grade pay. 1,500 revised to 3,900. 1,600 revised to 3,900. 1,800 revised to 4,400. My pre-revised pay was, grade pay was 1,800. Your lordship. So it has to be revised as 4,400. But in annexure, while fixation, your lordship, may kindly see annexure 6, page 57, your lordship. 57,
Yes,
your lordship. Serial number 7. The pay band and the gross pay, pre-revised gross, grade pay was 1,800. Your lordship got serial 7. But revised grade pay has been fixed as 3,900, your lordship. It should be 4,400. So it's a matter of calculation. the respondent number 3 and 4 can.
There are representations pending, my lord.
So let the representation be disposed of.
Yes, yes,
Item 58, page 58.
your lordship.
Origin. Which representation do you want to be disposed of?
Representation, there are.
There's so many of them. Which one do you want?
Latest one is page 63,
63,
62 and 63.
60, annexer 8 will do, your lordship.
Annexure
There are
8.
details, page 60.
60.
Give it to-
এখন special DD code.
So page 61 will do.
Yeah,
Page 60.
Heard Mr. R. Majumdar, learned counsel for the petition. Also heard Mr. B. Kaushik for the
Secondary education.
secondary education department. Ms. R. M. Baru appears for the
Respondent two, your lordship.
respondent number 2. And for the accountant general,
No, B. Sharma was there.
Huh?
B. Sharma was there.
well,
He was there. Brijas Sharma.
well,
9.
who?
R.K. Talukdar.
Well, Mr. R. K. Tarukdar appears for the accountant general, Assam. The grievance of the petitioner is regarding wrong fixation of grade pay. It is the submission of the petitioner that the petitioner's existing grade pay of rupees 1,800 is to be revised to 4,400 in terms of the resolution on the report of the 7th Assam Pay and Productivity Pay Commission and the report of the committee with the Assam Service bracket revision of pay bracket close rules 2017, including revised pay structure schedule, bracket department wise, bracket close, page 49. However, the petitioner's grade pay has been revised to, grade pay of rupees 1,800 has been revised to rupees 3,900 instead of 4,400. Next para. The petitioner's counsel submits that the petitioner is a grade 4 employee of the Janata High School, Latimara, this Kachar district.
Katiwara district Kachar.
Numerous representations have been submitted by the petitioner, which has not been considered by the respondents till date. He accordingly prays that a direction be issued to the Inspector of Schools, CDC Silchar, but
3 and 4.
to the respondents number, and
Next
4.
8 was to the respondent number 3. Direct.
Okay, respondent number 3 and 4. To take a decision on the petitioner's representation, especially the representation dated 17/11/2021, which is at annexure 8 of the writ petition. Next, Mr. B. Kaushik, learned counsel for the just say the learned counsel for the respondents submit that they have got no objection to the prayer made by the petitioner's counsel. Next para. In view of the consent of the parties, the respondents number 3 and 4 are directed to take a decision on the petitioner's representation dated 17/11/2021 with regard to whether the petitioner's grade pay should be rupees 3,900 or 4,400 per month. Full stop. Full stop. In the event, the petitioner is entitled to the grade pay of rupees 4,400 per month, the grade pay and should be corrected along with payment of arrear pay,
Consequential benefit.
if any. The entire exercise should be concluded within a period of
2 months.
2 months from the date of receipt of a certified copy of the form.
And along with the.
Along with a copy of this writ petition. The writ petition is accordingly disposed of.
Timing, Lordship.
I'm being,
Timing, Lordship.
in this case, I have to file affidavit of opposition.
You want to file?
affiliation opposition lordship regarding the affiliation was cancelled for the
Yes, the affiliation was withdrawn.
John lordship. The clause was also mentioned because
Where is where is the senior?
Another court was.
On the court. Anyway, right, then he might have something to say, I don't know.
yes.
Let us wait. Yes,
Yes, my lord.
you see, you had filed this writ petition
Yes.
because your caste certificate was cancelled, correct?
Yes.
Now the caste certificate has been sent for scrutiny
Yes.
to the concerned committee, correct? Now the concerned committee has taken a decision
Yes.
and apparently you have challenged that decision.
Yes.
So this writ petition has become infructuous. What remains?
I have no problems, provided, my lord, that my interim order, which has been given to me, by which I am on now got my admissions, that should not be disturbed. Subsequently, after this, there was an inquiry. Inquiry is also then the report has come. So that is also under challenge. I have that order. I'll give it to your lordship just now. So if that is protected, I have no problems. But
There is no interim order in the other one.
no, this is the notice on interim. That's the order which I have given your lordships.
Where is the cancellation of the order?
Yes, my lord, that is in the other petition. Cancellation order. This is. My lord will have a writ petition 4440. Or your lordship says the other one because it's in 4440.
4440.
There are two writ petitions, your lord.
Okay, 4440.
Yes, in that they have filed it at page 85.
Page?
85, annex 19.
Not page 85.
Yes, ma'am. This is by the DC. Page 85. The relevant portion is at page 86.
Yes.
Yes, that's the relevant portion is at page 86. Based on the ground of report, after inquiring in the neighborhood of the applicant, it has been learned that the family of the applicant does not follow rituals and customs of the T tribes community and does not belong to the TGL and ex-TGL. Based on this, above facts concluded caste certificate issued to Soto may be cancelled.
So now, you see, so the committee has taken a decision. Why should we stay it? Why should we stay?
Because
They are the
lordships will
authority
come-
to
your
decide.
lordships will come to the notification. So that's at page 94 in the same writ petition. Same
Yes.
writ petition, page 94. If your lordships will come to page 95, clause number 9. The
Yes.
orders passed by the committee shall be final and conclusive only to subject to proceedings of 226 of the Constitution. So that is all pending. Everything is under consideration. Therefore, my request is. your lordships,
This is the, but
This is the notification under which the proceedings are initiated in terms of the Supreme Court judgment.
This order is of 11 May 2018 and the impugned order is of 22/8 to 2024.
Yes,
And subsequent to this,
yes.
this has got nothing to do with this.
No, but this is the notification that is followed. This is
Yeah.
the notification which is always followed.
The
in terms
order
of
passed by the committee. Which committee?
That's the essence.
This
This is,
Okay, yes, Mr. Dhar.
Pilot. Since already the state level scrutiny committee is in its own wisdom and finding has passed an order, my lord, and that is under challenge. And there is no stay in that impugned order, my lord.
There is no
Every-
stay in that case.
That case,
Ah.
every, my lord, every interim order has to be passed on the impugned order, my lord. The court has already, my lord, applied its mind and they did not interfere. Meaning thereby, Photos
So,
are certified.
yes, so that case is still pending.
That is still pending.
Then
They have
file an
to,
affidavit. Let's-
they have to,
actually
my
hear
lord,
me out.
if any interim order is, my lord,
The interim order passed is only with regard to the order dated 22/8/24.
Yes,
Then,
this one, this writ petition,
correct. So
This
this,
repetition,
this has become infructuous.
this writ petition.
We will see your challenge to the subsequent decision made in that writ petition.
Right.
But
Which
this
is a
writ
subsequent
petition
writ
is closed. This writ petition become infructuous. There's nothing here.
May I say this, your lordships? If this order is vacated, your lordships, my entire premise of my admission is based on this admission, of this order. Subsequently, the inquiry report which has
No,
been
no,
filed
it
is
cannot
already
be.
under challenge.
Cannot be.
All I'm saying, my lord, is here, I let this matters be taken together and be heard. Otherwise, I'll be prejudiced in terms
How,
of.
how will you be prejudiced? You tell me. In,
This
in,
is subject-
in
the
this
second
writ,
order which has been passed, my
in-
lord, is subject in
in
this writ
this
petition.
in this writ petition, what have you put to challenge?
Yes,
Let us see your prayer.
yes, my lord. 4-4, my lord.
To quash the 22/8.
Yes, that's at page 43.
Ah,
First is to quash, set aside and quash the impugn order.
correct.
Second, it shall not be stayed is the letter dated 27 issued by the deputy
Let us see
commissioner.
this 22/7.
Lordship.
Where is 27/8?
Yes.
Where is this?
That is, my lord, at. My lord, that is at. 27. Just 1 minute, my lord. I'll just give a lordship 27 letter. 27 letter. Yes, page 24, my lord. Oh, sorry, 84. 84. I'm extremely sorry. Page 84, annexure 18.
Yes, then.
And then, my lord. The next is that the list which has been published for admission, which is on 29/8, not selecting the petitioner, that should also be stayed. That is the list which was published and my seat has been now kept vacant.
Where is it? Which page?
Yes, my lord. This is 29/8, my lord. This is page 83, my lord. 82 and 83, Polly.
'82.
And 83. And at page 83, at the bottom, 2192 is withheld. Tejpur Medical College. Intel motor, this one, much of it all. 444. September or September. Oh, it is.
Yes, how is this page 82 relevant here? Which portion?
This is. We are concerned with page 83, my lord. That's a notification on the basis of which the list has been published. Page 83, 219 to the last column. Withheld.
21
XTGL,
2192.
yes, the last column.
So it's
OBC
withheld.
XTGL resident of so-and-so, Tejpur Medical College. That's where I've got an admission. And the order is at, the order which was passed on the 2nd of September at this honorable court.
So it still remains the same.
Yes,
Then,
lordship shall see that order which is passed on 2nd of September by this honorable court. In the interim, the order that it's so-and-so issued by the district conjugal Golaghat cancelling the certificate of the petitioner shall remain stayed. Further, the Director of Medical College, Assam, is directed to keep one cent reckoning in Tejpur Medical College, Tejpur, for the admission into the first year of MBBS in 2024 under TGL quota till the next returnable date. So I am under this protection, my lord. It is subsequent to this that an inquiry is done, and now the SLSA has passed a report saying that this is to be put forward for cancellation. All I'm saying, lordships can tag all these matters can be heard.
My lord will just peruse, order dated 6/9/24. My lord's order, my lord.
6/9/24.
My lord.
In
Writ petition number
4087.
4087, my lord.
6/9. 26/9 or 6/9?
6/9, my lord.
6/9, yes.
069, my lord.
Yes.
My lord will just peruse his order. Why state level scrutiny committee has gone into, my lord, there is a direction on the state level scrutiny committee, my lord, to examine the matter. That is why, and this state level scrutiny committee's final order is the fallout of this order, my lord. State level scrutiny committee did not go into finding. There was a stay. But this honorable court has directed the state level scrutiny committee to examine the my lord certificate. And state level committee after an inquiry has found that, my lord, he doesn't belong to.
So that is what I have challenged
My lord.
in the subsequent.
So now, my lord, unless that the present order of the state level committee, my lord, is put to challenge, and there is a stay, my lord, this will prevail, my lord. He has to get a stay there. This is subsequent.
So you see, there is one thing. Let us see this page 68. No.
Page 68, my lord.
Huh?
Page 68.
What has happened to the other case, 824 of 2025?
Notice is issued, your lordship. They are supposed to, so there is the pleadings and it's supposed to be listed anytime.
We'll list that tomorrow. This will dispose it of.
At this stage, your lordship don't mind.
Okay, but we're disposing of this matter.
Let this also come up together, the same. Let this also be on record.
There's nothing here. Your prayer is only with regard to the withdrawal of the caste certificate. That is gone. That issue has gone now.
Lordship, make it on Wednesday.
To consider the caste certificate issue, direct the issue. To consider the caste certificate issue. In the meantime, you keep the seat vacant in the test board. That's
I'm
all.
already studied.
You already studied.
Yes, madam. That's the order I said, 2/9/2024, passed in 4/4/0.
Now, my
No,
lord,
but that 2/9 is only to keep it vacant. It's not allow you to study.
Yes. Your lordship.
Where it says here, further the director of medical education is directed to
seat
keep
vacant
one
for
seat
admission.
vacant
For admission,
for admission into
so I have
the
already,
till the next returnable date. And today is the next returnable date. How can you join?
in
Who has
terms of
told you
this-
to join?
This is in terms of this order, lordship. the
No,
protection that I've got.
this is wrong. There is
The-
no order
the
here.
admission process is complete.
Maybe.
I have been admitted in terms of this order itself, your lordship.
No. There will
The
clarify
council
that.
was available, everybody was available when the interview happened.
I do
everybody-
not know if it was done, it was done. So then if you have joined, then what's your problem?
My problem is
With
this order protects me, your lordship, to the extent. And I have already
No,
subsequently
this-
challenged the entire inquiry report, which is in terms of this notification.
No.
In terms of the guidelines, they done by the
You have
Supreme Court.
somehow done it. This order is only to keep a seat vacant for admission till the next returnable date. To keep it vacant.
Correct.
It says vacant. Once you join, it's not vacant anymore.
Once the process
Right.
is complete, your lordship, I will
Heard,
have
Mr.
to RB Fukan.
RB Fukan. Learned counsel for the petitioner. Also heard Mr. R. Dhar. Learned. For the petitioner in both the cases. Huh?
Yes, madam.
Heard Mr. R. Dhar. Learned counsel for the
2/5, my lord.
for who? For
2/5.
in both the petitions.
My lord, I will just check. No, WPT and BC, my lord, is right.
Huh?
WPT and BC. The department,
WPs,
WPT and BC.
WPT and BC department. Mr. B. Gogoi appears for the health department. While Mr. G. Pegu appears for the state government. For state government. The petitioner herein is a candidate seeking admission to the first year MBBS course. MBBS course under under the Directorate of Medical Education, Assam. Under the TGL/EX-TGL category. For the purpose of availing admission under the TGL/EX-TGL category, there is a necessity for producing a certificate of the TGL/EX-TGL community to be issued by the competent authority. Full stop. Next para. In the present case, in the above two cases, the petitioner had, where is your certificate, initial certificate?
Yes, madam. Page 49. Then the next page is 50,
The
the
petitioner
online certificate.
has projected himself to be a projected himself as belonging to the TGL/EX-TGL category. As he is of the Koiri community. KOIRI community. In terms of the caste certificate issued by the Office of the Chairman, Subdivisional OBC Development Board,
Yes, ma'am.
Golaghat.
Yes. So the online one is by the approving authority. Next page, page 50.
And dated, the first one is dated 31/12/20.
20.
While and another caste certificate issued by the Office of the District Commissioner Golaghat, dated 30/10/2023. The petitioners, next para, the petitioner was thereafter issued an order dated, issued the impugned order dated 22/8/2024 by the District Commissioner Golagat, wherein the petitioner's caste certificate dated 30/10/23 was declared to be cancelled on the ground that the petitioner did not belong to the TGL/EX-TGL category. Next one. The petitioner's counsel submits that subsequent to the above events, the petitioner who had taken part in the NEET MBBS exam had been permitted to participate in the counseling, which was held from 21st to 29th of August 2024. However, the result of the petitioner has been withheld in view of the cancellation of his caste certificates by the Office of the District Commissioner Golagat.
My lord have said the result is the
Huh?
seat. My lord have just now said result to be withheld. It is the seat to be withheld. That's the notification. I read it out to your lordships.
That is what the court has held in the earlier order.
Results were already declared.
The seat was withheld. Just the
Yes,
result
that's
is
what
seat.
page 83 says.
Anyway, this was here in this
Yes.
earlier order passed in 2924. 2924. People 40 of 2020. Next. Right. Pursuant to no, in view of the cancellation of the petitioner's caste certificate, the petitioner has filed the above two writ petitions with the following prayers. Number one, that the impugned order dated 22/8/2024 cancelling the petitioner's caste certificate should be set aside. Number two, that next, the letter dated 27/8/2024 issued by the District Commissioner Golagat directing the petitioner to deposit the original caste certificate issued from the office at the facilitation branch, District Commissioner's Office, Golagat. And number three, to set aside the admission notice dated 29/8/2024. Wherein the name of the petitioner has been withheld while publishing the admission notice bearing admission notice bearing number DME/UG/17/224/535433/4 dated 29/8/2024. comma, thereby not selecting the petitioner for admission into the first year MBBS state quota seat. Is it for you're for the dental or for MBBS?
This is dental. Seat for I'm for MBBS. This is the seat at government medical
stop.
and dental
Ah.
colleges. Page.
Next. Subsequent to the above events, comma, the state level scrutiny committee issued, has, state scrutiny committee constituted in terms of the decision of the apex court in the case of Kumari Madhuri Patil versus the additional commissioner. So reported has
The notification is 2010. Subsequent to that.
considered the case of the petitioner and a final decision has been taken by the said state levels caste scrutiny committee on, where is that?
Yes, ma'am, that's on this. The other writ petition, the 1/2/2025.
1/2/2025, comma, wherein where is the decision?
That
Can you
will
give
not
me a
be-
copy?
Because that writ petition is not listed today.
That is not listed today, my lord.
That will not be, this is with me, I have got it.
What date? The decision to the effect that,
1/2/2025
no, take a decision on 1/2/25,
for recommendation for cancellation of the caste certificate.
which has recommended
Recommendation, yes.
recommendation for cancellation of the petitioner's caste certificate. Next paragraph, the petitioner's counsel submits that the recommendation for cancellation of the petitioner's caste certificate made by the state level
State level scrutiny.
scrutiny committee on 1/2/2025 has been put to challenge in WPC 8/24/2025. Next part, which is pending in this part. He further submits that in terms of the interim order dated 2/9/2024 passed in WPC 2/9/2024, the petitioner has been admitted into the Tezpur Medical College for the first year MBBS course. What's up? Mr. Ardhar, learned counsel for the. This is 2/9, 2/9/24. Mr. Ardhar, learned counsel for the respondent submits. No, this don't say that. The counsels for the respondents, comma, on the other hand, submit that the present writ petition has become infructuous in view of the fact that the state level scrutiny committee has already taken a decision dated 1/2/2025 for cancelling the petitioner's task set. Next para. On considering, no, I find, no, just say, the order dated 2/9/24 passed by this court in WPC 4440/2024 has directed that in the interim, the impugned order dated 22/8/2024 shall remain state. And that the Director of Medical Education, Assam, is to keep one seat vacant in Tezpur Medical College, Tezpur, for admission into first year MBBS/BDS course session 2024 under TGL/EX-TGL quota till the next returnable date. No further order. No, thereafter. Next para. Thereafter, this court, in its order dated 6/9/2024, passed in WPC 4087/2024 with IAC 2646/2024, in WPC 4087/2024 with WPC 4440/2024 has stated has given the following direction. Invert commas, recording the submission made by the learned government advocate, Assam, the state level caste scrutiny committee is directed to verify the caste status of the petitioner and take a final decision within a period of 2 weeks from today, particularly, taking into consideration that the admission of the petitioner to MBBS/BDS course is hanging, inverted commas close. Next para. In the order dated 26/09/2024, passed in all those cases, this court had directed the Director of Medical Education as well as the principal, Tezpur Medical College, to give provisional admission to the petitioner for the first year MBBS/BDS course for the session 2024-2025. Full stop. However, such provisional admission would be subject to the outcomes of this writ petition. Full stop. Next para. On considering all the above, I think we'll list that matter also, otherwise he will not be protected.
In fact, 6/9, your lordship said just now read it out, it specifically says that this is directed to verify the status. And in terms of that, your lordship said 2018 notification. If your lordship will kind enough to come to page 94, that notification, page 94 is the order of the governor. I'm sorry, it's not very clear, but it said in terms of the Honorable Supreme Court judgment and in the partial modification of the earlier notification dated 18/5/2009. I'm reading the top paragraph of page 94, constituting the state level scrutiny committee, the governor of Assam is pleased to reconstitute the state level commission. So this was done in 18/5/2009. And in that, at page 95 is where it says the orders of the committee shall be final and conclusive only to the subject proceedings of 226 of the Constitution. That page
Right,
95.
Right. On considering the procedure number 9 of the notification dated 11/5/2018 issued by the Commissioner Secretary to the Government of Assam, WPT and BC Department, which states that the order passed by the State Level Scrutiny Committee shall be final and conclusive only subject to the proceedings under Article 226 of the Constitution of India, comma. This court is of the view that the matter be listed again on Wednesday. On Wednesday, yeah, along with WPC 824 of 2025.
Great.
2025.
25. Grateful.
That notification is valid as per the Madhuri Patil guideline, madam.
As for the
Madhuri Patil guideline, that is there in the Madhuri Patil, that it is only challengeable in 226.
Huh?
In 226, this SLSC order can be challenged, madam. That is there in,
correct.
that is there. That is why we have just followed, my lord, Madhuri Patil guideline. That is there, correct.
So why don't you file the affidavit in that 825, 824 of 2025?
That's what I said, Your Lordship. They can file an affidavit, can be heard finally.
My lord, if it is notices,
No, day after tomorrow we'll dispose of these two cases.
Fine.
We'll keep one, but only thing is for the sake of that interim order of thinking.
keep out of order to just. My lord, here, this order, my lord, state level scrutiny committee, this falls within now the domain of social justice. So I think my friend RM Das will respond to this.
He asked for us to take time. He asked us to take time because he didn't know the case.
Was not aware of it. That's the reason it was mentioned in the morning, but then I think.
Anyway, no, let us, so that we are clear now. So Wednesday, what we'll do is I've just put this all together because I thought, there's no point keeping all these things pending. We'll dispose of the rest, only one issue remains. Only thing is with regard to whether they
Yes.
should be given some interim protection because already court has given some
Great. That's why.
interim order.
Exactly, madam. If
So
my
let
lord
it
gives
come on
protection,
Wednesday.
given protection on this new, my lord, is,
But already given, no, that is the problem now.
that is before, my lord, passing of this state level scrutiny committee order. Now, my lord has a
Then why don't you file your affidavit? File your affidavit. I will dispose of the entire matter. This is from where? This is from the file. Task. Anyone you can put in idea. Just task routine is that one. Item 11.
Lordship, in this case, the departmental counsel has to produce instruction document.
Yes. What is your prayer?
Lordship, for provincial election, my name has dropped, Lordship, at the time of provincial because
When? Dropped when?
2013,
2013.
Lordship.
And you have come to
Then
this
after
court.
I approached this court, Lordship, because my name was then again when I acquired the.
You came to this court
educational
earlier.
qualification, and this court directed to dispose of my appeal. That has not been done. That direction, Lordship will find at page 45.
Okay, so which one? Which page?
My lord,
The notice or the 5th April?
fifth April, my lord.
They're both 5th April.
My lord, not notice, my lord, instruction part, my lord.
Huh?
Instruction is also there, my lord, to forwarded to the
Petition of WPC number 53, okay. Okay,
In reference to the earlier case, my lord, he has approached the department on 9/9/2014.
okay, so his case is going to be considered on
My-
23/4.
My lord.
Correct. Ms. S. Tutia, Lieutenant Counsel for the Elementary Education Department submits that the petitioner's request for provincialization of his service is going to be considered in the SLSC that is being scheduled on 23/4/2025. However, a copy of the writ petition in WPC 1097/2021 has not been received by the Office of the Joint Director Elementary Education, SM. Mr. B. Chakrabarti, the counsel for the petition, shall provide one extra copy of WPC 1097 of 2021
After this.
to Miss S. Chutia during the course of the day. During the course of the day, within 2 days. Within 2 days. Ms. S. Chutia shall thereafter forward the same to the Office of the Joint Director Elementary Education, who shall place the same before the concerned SLSC. Comma, if required by them. The writ petition, the list the matter accordingly. After vacation.
In the month of May, Lordship, because 23 meeting is scheduled on 23, Lordship.
It'll come in time, it'll come. No hurry.
May I repeat a lot? I'm extremely sorry to say it, my lord. Today it has come to my knowledge, my lord. There are two paras who have
You cannot change it just like that.
and may be allowed to file IA.
What is this? You're doing it by hand without permission of the court also.
There is
What is this?
this cancellation matter, my lord.
Huh? You cannot cancel as you want.
I'm extremely sorry.
This is not, you see, first of all, you need permission of the court. And secondly, usually what happens is this kind of cancellation, amendment of the, you should make an application, not this way. What is
I may
it?
be allowed to file IA.
Huh?
Withdraw কৰি এটা নতুনকে ফাইল কৰিব সেইটো বেছি ভাল হ'ব আকৌ সেইবোৰ কিবা
Instruction of one.
আলটিমেটলি আপুনি ফাইল কৰিব টাইম লাগিব
Then I may be allowed to
Huh?
withdraw and to the liberty to fight it.
সেইটো বেছি ভাল হ'ব
Mr.
That's all.
S. Chauhan, learned counsel for the petitioner, says that he may be allowed to withdraw the writ petition with liberty to file afresh. Miss S. Tuti appears for
1, 2, 3, 5 and 6
1, 2,
5 and 6
5 and 6. Mr. B. Sharma for
4
4. Who is for 3?
মেলে গভৰ্ণমেণ্ট আপুনি
Mr. G. Pegu appears for aspirant number 3. The prayer the petition's counsel is allowed, writ petition dismissed as withdrawn, comma, with liberty as paid for.
It's a compassionate appointment case. Pending matter.
Okay, Mr. I alarm. Yes, same.
After 9 years, my lord, application.
How does it matter? It has been agreed by you all. It is your, you see, now, Ocha, he has not challenged that 19.
My lord, I have not challenged my lord. that is-
Oh, you have not challenged, okay. Then,
I have filed this on October.
then
9.
we will hear you.
We don't know about this. my lord.
No, it's okay. Bad luck. What to do? Can't help it now.
My lord.
So then we will have to decide this case on merit. So father died on 1/9/2015, correct?
15 months. Yes, my lord.
Then mother applied, but was not considered by the authority, correct?
My lord.
So why hasn't the mother come? Who are you?
Subsequently, petitioner have approached before the.
Can
CEO
you,
provided the same.
supposing can there be more than one application for compassionate appointment?
Mother have already withdrawn my lord.
No, where have you said mother has withdrawn?
My lord, may I kindly peruse page 22, my lord.
22,
That is the forwarding of submission of application.
22, 20. Yes,
With reference to subjects, I have the honor to submit here with the applications of Nazarul Islam, such and such, wherein she stated he was willing to apply appointment compulsion against his deceased father, approves at deceased at so and so 1/9/2015. Further, she stated that that at the same time his father he was a minor. According to his mother, Shukla Begum has applied for appointment compulsion on 5/11/2015, but the said application could not be forwarded to your end as Shukla Begum, wife of deceased here concerned, was underqualified, plus 4 pass, as well as overaged. Later, his mother submitted application dated 1/22 copy and post, wherein she prayed for considering her son Azharul Islam as an applicant in place of her. Subsequently, Azharul Islam has applied for appointment compulsion against his deceased father. Considering the above mentioned facts, I therefore request your honor kindly look into the matter and take necessary steps with your honor deem it fit and proper, and can in this connection, the original prayer petition along with other relevant documents in respect of the applicant concerned is enforced herewith for favor of your kind information and necessary action. That's up to you,
yeah. You applied in 2024.
my lord.
Father died in 2015.
My lord. That's true, my lord.
No case.
It's up to you.
Sorry, I know. If there was something, okay, we could have considered, but not this.
In that
There
case,
there is nothing here. Yes,
my lord, in that case, my I may be allowed to do it liberty, my lord. I will challenge the notification, my lord, with your logic.
no, now there's no question of challenging, no. Right. Heard Mr. Ayala, learned counsel for the petition. Also heard Mr. G. Pegu, learned counsel for
Respondent number 3, my lord.
point number 3. Mr. R. P. K. Bora appears for
One and two.
1 and 2.
1, 2, 4 and 5.
The petitioner's case, the petitioner's grievance is that his application for compassionate appointment submitted on 1/2/2024 has not been decided by the authorities till date. The case of the petitioner is that his father died in harness on 1/9/2015. The petitioner's mother thereafter applied for compassionate appointment on 5/11/2015. However, the application of the petitioner's mother was not considered by the authority. The petitioner's counsel submits that the petitioner's mother, being a class 4 pass, she was not qualified to be appointed to a grade 4 post. And accordingly, the petitioner's mother had thereafter submitted an application dated 1/2/2024 on behalf of the petitioner for enabling the petitioner to be appointed on compassionate grounds. Next paragraph. Mr. G. Pegu, the learned counsel for the no, this is the counsel for the respondents. Submit that more than 9 years have passed since the date of death of the petitioner's father, and it can be assumed that the petitioner and his mother have been able to tide over the sudden financial crisis that had been caused to the family due to the death of the petitioner's father. He was working as what?
My lord, assistant teacher.
Assistant teacher. Must be getting pension also.
My lord, I have also annexed this.
You know, they also submit that the petitioner's father had expired while being an assistant teacher in a school. And the, and as the petitioner's mother was receiving family pension, it cannot be said that the petitioner and his mother were living a hand-to-mouth existence.
Order is page 24, my lord.
Huh?
Page 24, my lord.
Pension. But I have said, yes, sir.
Page 24, my lord.
Okay, basically dismissed. I'll continue later. Dismissed.
My lord.
Okay.
May I please, Lordship? We initially made a prayer for listing the matter after review vacation because there is no after the instruction with regard to the pen.
What are you challenging here?
But challenging the the order by which the DP was continued to.
Why? How can you challenge the
telling
show
that-
cause notice?
No, disciplinary proceeding has already started, Lord.
Then they will become infracted.
Lordship,
How can you challenge the show cause notice?
you have challenged the disciplinary proceeding, Lordship.
Why? On what ground? You take part.
Yeah.
How is it prejudiced you?
Lordship. Lordship will, Lordship, can we fix it after the review vacation?
No. There's no point.
Lordship,
You
also kindly.
you see, there is a notification by the High Court that if you want to adjourn, please give a application 1 day beforehand,
Lordship,
so that we don't have to read and waste the time.
Lordship. And also.
You tell
Lordship,
me why? Why?
also on the last occasion, Dibrugarh University.
The inquiry is yet proceeding. He had asked for a defense counsel. He wanted to be represented by a lawyer, by a counsel. We have allowed that also.
You've allowed?
Yes.
How? Why?
We have
Because
allowed
the
presenting
officer is a lawyer.
He's a person qualified in law. He's not a practicing lawyer. He's qualified in law. He made an objection that I want a lawyer to be with me. We allowed that also. Charges, Lordship will see, are not charges which can be.
No. How can
Eyes cannot
there's
be
nothing?
charged.
How does it prejudice you?
Brahmadat Sharma will cover everything.
Huh?
Brahmadat Sharma case, 1987, it covers the whole issue.
What is the citation?
1987. I'll just give it. Lordship would give me 1 minute.
I'll leave it to Lordship to decide. I'll not praise much on the issue as it will be.
Well, my view is that prima facie view is that it should be dismissed.
Lordship.
How can you challenge a show cause notice? Basically, it's challenging a show cause notice.
Also,
The initiation of a DP.
Initiation
Yes.
of the proceeding, Lordship.
Show me,
Our
Show me-
challenge was that,
show me the charges framed against you, page.
page 100, Lordship.
19.
Lordship will, 40. Lordship will, pardon me, Lordship is 44, page number, annexure A.
179.
Charges will be at page 45. Lordship.
Was it regarding that video clips with regard to that girl?
In fact, he was arrested 2 times thereafter on similar charges of running an entire show in his hometown. He was released yesterday or day before yesterday, if I'm not wrong.
No case, Mr. Counsel. Well, in fact, the show cause notice, the charges framed against you, they're very polite. They are, they have not been graphic. I mean, you don't know what are they talking about unless you read slightly between the lines.
Lordship.
Suppose notice will be challenged now.
And you were in the video, no?
Lordship.
You were the person.
Lordship. He has denied the
Yes,
involvement. in-
para?
Lordship, that is, second last paragraph, my lord. High Court was not justified in quashing the show cause notice when a show cause notice is issued to a government servant under a statutory provision calling upon him to show cause. Ordinarily, government servant
Yes.
places case before the authority concerned by showing cause, and courts would be reluctant to interfere with the notice itself.
Okay, right.
And there's another one,
Heard,
this
Mr.
Honorable Court, 2016.
D.
D. Deka, learned counsel for the petitioner. Also heard Mr. R. Majumdar, learned standing counsel, Dibrugarh University. The petitioner has paid for setting aside.
106.
Huh?
Double one.
Page
For
number
set-
106.
For setting aside the disciplinary proceeding that has been initiated against it on the ground that the same has been made on the basis of mere suspicion and there is no prima facie case against the petition. That's okay.
And another is they have charged in Article 30 and 31 of the Dibrugarh University rules. The 31 doesn't say what is misconduct. It only prescribes.
Okay, he also submits that the petitioner has been charged under Article 30 and
30
31.
and 31, Lordship,
30 and 31
of
of the Dibrugarh University
Teachers'
Teachers
Service
Service Conditions
ordinance.
Ordinance, 1974, hereinafter referred to as the ordinance. However, section 30 and 31
Lordship,
of the ordinance,
30 says what is misconduct. 31 doesn't say. It only prescribes the standards to be maintained by a teacher. Doesn't say.
he submits that though Article 30 speaks of misconduct,
Lordship,
Article 31 does not prescribe the standards.
prescribe the standards to be maintained by a teacher in a
The,
university, but
the
does not say
Article
what it
31
is.
does not prescribe the standards to be maintained by a teacher.
It does prescribe, but it doesn't say it is a misconduct if not adhered to those standards.
Okay, that's while Article 31, though prescribing the standards to be maintained by a teacher, it does not provide that the charges framed against the petitioner amounts to misconduct, is it?
Lordship.
Okay, right. On the other hand, Mr. R. Mazumdar, the learned counsel for the respondent university, submits that the registrar of the university was sent some link of an adult website by an employee of the university, wherein certain videos were available. Full stop. In the said videos, the petitioner was seen to be having, seen to have engaged, was seen to be engaging in pornographic acts with some unknown female.
Lordship, that's the allegation.
Huh? No. The respondent number 3 thereafter issued a show cause notice dated 26/6/2020 to the petitioner with the above allegations, and only then did the petitioner come. No. Don't say that. Just say because of the above. There were some other videos also.
No, there were around 7-8 videos.
There was
of the
various
videos, and
videos,
then
yes.
he's lodged an FIR again, alleging that these were not uploaded by him. Well, there was this time when all cases where punishment was less than 7 years were allowed to be withdrawn by the government, the notification had come. In that process, our FIR which we had lost, where there was a charge sheet, it was withdrawn by the government, but the disciplinary proceeding continues. Now he's participating in the disciplinary proceeding. So we just want to find out, come to.
Okay, right. Mr. R. Mazumdar submits that it was later found that there were around 7 videos in which the petitioner was seen to be engaged in pornographic acts with unknown females. Pusta. Correct?
That is the allegation, which is denied.
You haven't seen the videos?
I was
Only acted in them. Pusta. Thereafter, the respondent number 3 also filed an FIR before the Dibrugarh Sadar police station, some of which was registered as Dibrugarh PS case number 1044/2020 under section 294/500/506 IPC, read with section 67 bracket capital A of the IT Act. The petitioner was arrested on 2/7/2020 and eventually released on bail on 16/7/2020. The police authorities have also filed a charge sheet on 31/12/2021 in the court of the CJM Dibrugarh under section 294/500/506 of the IPC. The petitioner was, however, discharged by the court of the CJM Dibrugarh, and there is no criminal case pending against the petitioner at present. However, the discipline proceeding, has been framed against the petitioner. Has been initiated against the petitioner.
Order is at page 100.
Huh?
Inquiry committee.
He submits that no prejudice has been caused to the he submits that no prejudice has been caused to the petitioner in as much as the petitioner has also participated in the disciplinary proceeding and had asked for a lawyer as a defense assistant. The same was allowed by the inquiry officer. And as such, as on date, there is no prejudice has been caused to the petition due to the ongoing disciplinary proceedings. Next. In the case of State of UP versus Brahm Dutt Sharma, reported in 1987, 2 SCC 179. It has been held that when a show cause notice is issued to a government servant under the statutory provision, ordinarily the government servant must place his case before the authority concerned by showing cause, and the courts should be reluctant to interfere with the notice at that stage, unless the notice is shown to have been issued palpably without any authority of law. The purpose of issuing show cause notice is to afford opportunity of hearing to the government servant, and once cause is shown, it is open to the government servant to consider the matter in the light of the facts and submissions made by the government and only thereafter final decision in the matter could be taken. Interference by the court before that stage would be premature.
Another question.
Not exactly to the point.
And then Lordship could have the other judgment has given 2016 judgment of this honorable court. Para 9 again.
Which one?
Matlab,
Acha, this one.
Praveen Kumar Barua, para 9 Lordship. The contours of.
Yes.
So far as the interference into the proof of pregnancy of charges are concerned. Same is answered in so and so wherein the law laid down is that interference with the court can be made only from charges framed with the imposition of particular. No misconduct or other irregularities so alleged can be separately made out. Or that the charges framed are so contrary to any law. On perusal of article so and so, it cannot be condemned. No misconduct is made out.
Okay, right. In the case of WPC 1511/2015, huh?
It is reported in 2017 1 GLP 297.
Where did it?
It's from the website. GLP is not.
It's not here. No.
Otherwise,
2017?
1 GLT 297.
The Supreme, this court has held at para 9 as follows. Proceed by that. Full stop. On considering the charges framed against the petitioner, comma. It cannot be said at this stage that the charges framed against the petitioner does not amount to a misconduct, and that the petitioner was not involved in the said misconduct. In any event, no prejudice has been caused to the petitioner at this stage of the departmental proceedings that has been initiated against him. In view of the decisions of the Supreme Court and this court, as referred to in the cases above, this court does not find any ground to exercise its discretion in the present case. Accordingly, the writ petition stands dismissed.
I'm being having 6.
By already, my lord, 4/4/24, my lord.
Yes.
Took time, my lord. Here is the case, my lord, where we are agreed by an order that we are.
Okay, let them file affidavit. Okay, right, Mr.
I should read.
Huh?
I should read.
I, Chaudhary, learned counsel for the petitioner, submits that the withdrawal of the affiliation of the school should be set aside. Ms. R. Issue notice returnable in 4 weeks. Ms. R. Bora, accept notice on behalf of
All the rest.
all the respondents. And praise for 3 weeks time or 4 weeks time. 3 weeks time. 3 weeks time to file affidavit in a position. Praise allowed. This is the matter after 3 weeks.
My lord, there is an interim.
Interim order to continue to the next week.
Actually, a date may be given, Lordship,
Give a
because
date.
we have to file a vacancy petition also. 9 of
Okay.
like.
Item 50.
And the contract petition that the husband
Okay, right. Heard Mr. S. Salim, learned counsel for the
MS
petition.
answered it.
Huh?
On behalf of MS answered on behalf of A. Salim.
MS so on behalf of Mr. R. Ali, learned counsel for the petitioner who submits that the order dated 18/12/24 passed in WPC 1916 of 2023 has not been complied with. Inasmuch as the respondents have not extended the ROP pay scale and other service benefits to the petitioner. Issue notice returnable in 4 weeks, steps within 3 days, leave the matter proceedings.
60.
Mr. Right, heard Mr.
PM recommend.
BM Decca, learned counsel for the petitioner, who submits that the excess drawn amount, which had to be recovered, which had to be given back to the petitioner, which had to be refunded to the petitioner in terms of the order dated 9/12/24 passed in review 95 of 24 has not been complied with. Issue notice. Steps within 3 days. List the matter of the points.
Not solution. 70.
May I please, your lordship? My lord, my learned friend, my lord, went to the office of the DSC, my lord, requested several occasions for furnishing the copy of the impugned minutes of the resolution of the DSC, my lord. But they are not providing and hiding it, my lord. Ultimately, we have filed an RTI. Lord, it will take some time, my lord. But my lord, with my humble submission, my lord, is that the letter in which, my lord, basing on which that the entire school was, this honorable court was pleased to, my lord, directed to examine the entire provincialization aspects of all the 3 teachers. Now, my lord, this singly, I have been, my lord, taken up. That is my grievance, my lord. If the whole exercise is not carried afresh, my lord, then prejudice will cause to me, my lord.
How can it be carried out afresh?
Because
First,
of
you
the-
tell me what kind of a teacher are you? Which
My
subject?
lord, my subject, my lord, was initially I was teaching as a, my lord, all subject. Then when the, my lord, district scrutiny committee recommended me as a social science teacher, my lord. Why it had been recommended, my lord, the answer, my lord, may be pleased to find is that page
You
55.
are a SME teacher. You are not social science.
No, my lord, initially, my lord, may kindly turn.
Yeah, is it your entire case?
My
I
lord.
think is based on you being a social studies teacher, correct?
My lord.
Correct? Then that is a wrong basis.
No, my
That's
lord,
all.
yes, my lord, the basis why it has happened, my lord. My lord, may kindly just for a moment, my lord, I want to draw my lordship's attention to only one annexure, my lord. If my lordship allows me, my lord.
Yes.
At
Allow.
page 55, annexure 14, my lord. May I read, my lord?
You cannot carry on going same issue.
My lord, with reference to the subject cited above, I have the honor to inform you that the respondent number 6, Sahidul Rahman, petitioner herein, my lord, was appointed as the headmaster by the SMC of so-and-so Madrasa on 18/1/2006, and his name has been recommended by the then DSC Walpara by minutes of the meeting dated so-and-so as social studies teacher for provincialization, and the petitioner was appointed as assistant teacher by the SMC of the said school on so-and-so. The respondent number 7 is a BA passed and the petitioner is higher secondary pass as per the academic documents, and as headmaster of the school, respondent number 7 was taught all subjects. This is for favor of your kind information and necessary action. So, my lord, respondent number 7 is the present petition.
All these issues have already been taken care of in so many writ petitions.
My lord.
In the earlier writ petition.
No, my lord, this honorable court, my lord, with all respect, my lord, this honorable court's order, my lord, if my lord may be pleased to take up the order, my lord, which we are relying on, is at
Yes,
page
madam.
47, my lord. If my lord issue notice, my lord, then the entire.
No.
Then
You've
the-
got-
Why?
If I'm correct,
My lord,
your entire case is based on that you are a social science, social studies teacher,
my
correct?
lord, my lord. Then, my lord, I may be allowed to withdraw, my lord, with the liberty to.
No
file,
liberty, no liberty, sorry,
right? No, no, my lord.
no
see,
liberty. No liberty.
Then, my lord, my submission for liberty may be recorded, my lord. Otherwise.
I
my
will
lord,
record, I will record. I will record your prayer for withdrawal, but I'll give a detailed order first.
My lord, it will cause a severe prejudice to the petitioner.
Naturally, but this is the third round of litigation
My lord, no options.
on the same issue which has been decided
No,
by
no,
the
my lord.
authorities.
My lord, this is the first ever
You-
writ
but-
petition. This
Huh?
is the first ever writ petition filed by the petitioner, my lord.
Maybe, but you were always a part of the writ
No, my lord,
petitions
in the
filed by
earlier,
the
in the
respondent
earlier,
on the
in the earlier round of litigation, though I am a party, my lord, I have not been heard, my lord. I have not been heard because it has been
Maybe-
disposed of
maybe.
on the motion stage, my lord.
These are disputed questions of fact involved. You can go to the civil court or to the
Then,
tribunal
my
if you.
lord, simple withdrawal may kindly be given, my lord, or I am not praying for liberty also, my lord. Without recording, my lord, any, my lord, married, it may cause severe prejudice, my lord. That's why I am humbly submitting, my lord.
No, wait. Just a minute. No hurry. I'll give you enough time. I'll give you enough time. Don't worry.
Yeah, only to- Lord, my service has also been provincialized also, my lord. Come for it. Dismiss me with one marriage. Fine. Raise it together. Huh? Huh? In fact, one submission I forget to make, my lord.
No, are you withdrawing or am I disposing of?
No, my lord, if my lord is not providing the liberty, my lord, then the, withdraw.
No liberty.
Then my lord can pass reason order. Well,
Okay. Heard Mr. A.R. Bhuyan. Yes, madam, anything to say?
If the docket period states 15, madam.
15 of the repetition. 50.
Already, madam, re-verification has been made, madam, by the DSC, madam. In virtue of,
Page
madam,
50.
50, madam, annex 12.
Yes.
My lord, with reference to the subject cited above, I have the honor to inform you that as per the direction of the Department of School Education Assam, by letter dated so the DLC Gwalpara was rescheduled on 27/4/2024, 24/7/2024 in connection with WPC number 4047/2023. One Shahjahan Ali Mondal versus State of Assam, and accordingly DSC Gwalpara has examined the proposal for provincialization of staff in respect of the KB Memorial MEM School, and as per the resolution number 2 of the minutes dated 23/7/2020, it is found that Shahjahan Ali Mondal, petitioner in other case matter, is the senior than the Sahidul Islam, and also directed the DEO to submit the proposal for provincialization as per seniority matter. After verification, madam, it was found that the petitioner in the other case is the senior most person, madam. And madam, if your lordship periods.
Just a minute.
yeah,
One
yeah.
thing. Just 1 minute. Yes.
And pair portion, madam, page 23, madam.
Page 23.
23, my lord. They are praying for, my lord, writ of certiorari should not be issued to set aside and quash, my lord. The improved resolution number 2 dated so and so adopted by the DLLC Gwalpur Assam in its meeting dated so and so. And that is also not annexed, my lord.
Yes, right. Heard Mr. A.R. Bhuyan, learned counsel for the petitioner. Also heard Miss S. Trithya, learned counsel for the
1, 2, 4, and 5, my lord.
1, 2, 4, and 5. Mr. G. Pegu appears for respondent number 3. No one appears for the respondent number 6 and 7, as no notice, as no notice has been issued to the respondents number 6 and 7. Then you take this order. This order, the order dated 28/3/2025. Now out here, at para 11, you'll have to take the order is this order dated 14/8/23, passed in WPC 4047 of 2023. You take it from Mr. D.A. Kayum, learned counsel, submits that the petitioner was appointed on. Not from there. Take it from there, huh? Till the end. It's already partly I've taken. Then. Then para 12, right? A perusal of the above order dated 14/8/20, no, a perusal of the above order shows that the a perusal of the above order shows that at the time the order was passed, at the time the order dated 14/8/2023 was passed, comma, the service of the writ petitioner had not been provincialized, but had been recommended for provincialization only. The petitioner has, however, now taken a different stand altogether. Full stop. Next paragraph.
My lord, that was the contention of the earlier writ petitioner, my lord. It was the writ petition was disposed of without hearing.
Were you ever provincialized?
Yes, we have provincial.
When?
We have
Which
funded
date?
the, my lord, order of provincialization.
Which date? Which date?
5/2/2021, my lord.
5/2/21.
Yes, my lord. No, it is the answer. My lord, this.
No, is it part of your writ petition?
No, my lord.
No. I don't know. You are hiding things from me so
No,
much.
my lord has already perused this and recorded in the order dated, my lord. 8/3, my lord. In the same writ petition, my lord has already recorded, my lord.
Huh? 5? Which date?
My lord, the order of provincialization is 05/02/2021, my lord. Para 9 of this writ petition, my lord, we have stated, my lord.
Anyway, right. No, full stop. Right. Stand all together, full stop. Though the petitioner has stated in paragraph 9 of the writ petition that the order of provincialization of service dated 5/2/2021 was issued by the Director of Elementary Education, Assam, in favor of the petition. And the respondent number 7. The said provincialization order has not been annexed to the writ petition. Full stop. The alleged, don't say said, this is alleged. Next paragraph. You are provincialized as what? As tutor, no?
As a tutor, my lord.
Not as a teacher, that's what, as a tutor.
No, my lord, as a tutor, my lord. It has been.
That's what, as a teacher, you have not been
No.
provincialized.
No, no, no.
That's what I'm saying.
Nobody is provincialized as a Milord teacher, except a very few one who has the qualification, Milord, and those who are underqualified, Milord. As per the NCT, they are now.
You cut that portion. Just say, a perusal of the above order dated 14/8/2020 passed in so. No, the earlier paragraph, the earlier paragraph. A perusal of the above order clearly goes to show that at the time the order was passed, the service of the petitioner had not been provincialized as a teacher. Make it clear. Okay. However, the petition has now taken a different stand altogether. Next paragraph. This court. Wait. Okay, judgment reserved.
Lord, may I pray, Milord, only one submission may be recorded, Milord, that under the statutes of 2000, under the statutes of 2017, Milord, under section 3(1)(11), there is no provision, statutory provision is prescribed that the provincialization should be basing on the seniority, Milord.
That is not the issue here.
Because, my lord, they are relying on the seniority dispute, my lord. That's why, my lord.
My lord, may peruse page 49, my lord. Here, my lord, a petitioner name has been recommended against social science teacher, my lord. But
That is
he-
what, that is what.
my lord, he
The entire case is this, the entire case is, his case is that he is a social studies teacher
my
or
lord, but
social
my lord,
science.
he himself submitted affidavit before the authority, my lord. He is teaching Assamese, my lord.
Where
It
is
is
that?
reflected in page
Even-
Just give me that.
My lord, even I applied as an Assamese, my lord, language teacher, my lord, for the purpose of my provincial. Now, wrong had been
I do not
committed by
know,
the DST,
I
my
don't,
lord.
yes,
Page
page,
49, my lord, decision part, my lord, before decision, my lord. it
page
may-
49.
Page 49,
No,
my
no.
lord.
Yes,
Before decision colon, my lord, it may also be pertinent to mention that in the affidavit made by the respondent number 6,
wait, which line, which line?
last line, my lord.
Last.
Last line.
First prayer, last line, my lord. It
Yes.
may also be mentioned that in the affidavit made by
Page
the
49.
Page 49, my lord.
Yes,
Affidavit made by the respondent number 6, Sri Sahidul Rahman, it has been mentioned that he is teaching Assamese subject in the school, my lord. He is Assamese
correct.
teacher, my lord. And his name is wrongly recommended for social science teacher by the DSM, my lord. That was my right.
My lord, even I applied for the Assamese post, my lord. Then now it has been wrong has been committed by.
Right, right.
My lord.
Just write one thing. The petitioner's case in of provincialization in place of the respondent number 6 is basically based on the ground that he is a teacher. He's a social studies teacher and not a Assamese teacher.
Huh?
Though the order dated, impugned order dated, though the order dated 22 to 24 passed by the Secretary to the Government of Assam Department of School Education has recorded that the affidavit made by the petitioner herein shows that shows that he was teaching the Assamese subject in the school. On the other hand, full stop, as such, the order dated 22, no, the order dated 16 to 24 issued by the Secretary to the Government of Assam Department of School Education has recorded the fact that the respondent number 7 has stated in the affidavit that he had that no,
He actually hoiked this, sir.
that the petitioner no, cut that, no need, that's all, not that, cut that. Okay. Further, in the letter dated 5/11/2024 issued by the District Elementary Education Officer Golpara to the Director Elementary Education, Assam, it has been stated that the respondent number 6 is senior to the petitioner here. Reserved.
Obliged, my lord. Highly obliged.
Supplementary motion 41.
Just say one thing, we cannot have, there has to be a finality on issues, Yes, item
41.
41, yes,
Yes, but in this case, not my grievance has been redressed, my lord, because
Huh?
I have been already reinstated.
You have already been
Reinstated.
restated, so it becoming factual. Mr.
A. Ali.
A. Ali, learned counsel for the petitioner submits that as the petitioner has been reinstated into service, the writ petition has become infructuous. Mr. D. Upamanu appears for the Higher Education Department. In view of the submission made by the petitioner's counsel, the writ petition is closed as infructuous.
I'm obliged.
Further stay vacating, I think 15 to 20.
Higher of the clerk of.
Before my senior starts, the copy of the interlocutory application which is listed today. That it was not served upon us, it is served upon from record. I see that this is served upon a person who is authorized to receive higher education's file, not secondary. I'm trying to trace it out, my lord. Your lordship can take it up some other day, my lord, or else I can take a copy from my friend also, Mr. Bora.
That is the problem then. I think.
Since morning I was trying to trace out.
Pray this, Lord. Because I don't think now today your lordship can hear this, since he doesn't have the paper. But this is relating to regularization. The effect of regularization of a teacher who was regularly with a open interview and fully complying with the requirements was appointed in 2010. They were called contractual teachers and on fixed pay, starting with 8,000, then it was raised to 14,000. Then in 2020, they were given the scale, basic. Then now, after 4 years, they are regular. But the effect of the regularization is that every month they are losing about 4,500 rupees.
Why?
That is the effect.
No, they were regularized. So you're claiming something.
We are not claiming anything. Interim prayer was in this application that at least it should not get reduced from what we were drawing at the time of regularization. Every month we are being denied 4,400 something. It can't, it's the first case I have seen, that one regularization.
I think he's going to say that he needs time for it.
Yeah, I know. But let them file the affidavit, let us complete.
I don't know. You first give him a copy.
I'll pick up.
No, he has the copy of the writ petition. He can file the.
No, he wants the interlocutory
No,
application.
interlocutory, let him file an affidavit properly and we will finish the matter hearing.
I don't know.
They have not filed yet.
In the petition, we have not yet filed the affidavit.
Now, when will you file? How much time?
Lordship will give us 3 weeks time, we'll file our affidavit in the petition. And in the meantime, if necessary, we'll file our objection in the interlocutory application.
Very good. We'll give a copy of.
Mr. D. Kaushik, learned counsel for the Secondary Education Department is granted 3 weeks time to file affidavit in a position as well as affidavit in a position. This is the matter after 3 weeks.
Right.
May I please your lordship? In this case, the petitioner's salary has been stopped from June 2018, my lord.
Huh?
Petitioner's salary has been stopped from June 2018 till today, my lord. And thereafter, this honorable court passed an interim order, my lord, that is, I have annexed in additional affidavit filed on 2/4/2024, my lord. And that is in page.
So you have been paid some amount now.
No, my salary have been stopped from June.
June or July?
June 2018. And
No, we filed our affidavit, my lord, and in the and an interlocutory application also, my lord, for modification of the interim order. Be that as it may, my lord, the interim order which was passed earlier by an order of this Honorable Court of 9/5/2023, it's already kept in abeyance, that interim order. Because the dispute herein, my lord, the petitioner has taken three stands, my lord. Once the petitioner says that, no, I have never applied for a mutual transfer. Then subsequently said, initially I applied for a mutual transfer. Once the mutual transfer order was affected. Thereafter, the petitioner's school, the earlier school, my lord, they come up with some representation saying that the petitioner should not be released. Period as it may, 36/2018, the petitioner, the other person, he was released, and that person has joined this petitioner school. And petitioner was also released on 36/2018, and on 2/7/2018, the petitioner has given a joining report in the new school. But petitioner in some pleadings has said that I joined that school, but I was not allowed to sign there, and therefore I have came back to the earlier school wherefrom she was released. Subsequently, in a written statement submitted before the authority, the petitioner says that, no, I have joined that new school, I have been continuing, but for some illness, I could not go some days.
Lordship,
But it is
I
an
may be allowed to submit for that. The thing is that the mutual transfer, that issue was the mutual transfer between the petitioner and respondent number 2, my lord. That issue was already been decided, and and inquiry was initiated by the inquiry committee, and the report was submitted. On the basis of the report, the Director of Elementary Education Assam suspended the respondent number 10 due to fraudulent attempt made by the respondent number 10. Thereafter, the petitioner joined in the newly transferred school, my lord, and he joined in the school, that and the school managing committee accepted his joining letter, my lord, on 2018. But the respondent number 10, he has submitted his joining twice, my lord. One is 30 and in the morning, and another is but after joining in the newly
Is
school.
pleadings complete? Pleadings are complete or not?
I have filed my affidavit, but my friend has not filed any affidavit in reply.
Lordship,
Reason that possibly they don't want to.
additional affidavit on last occasion, this honorable court has directed me to whatever the order, whatever the.
And I have the records of the new school, also the attendance book, my lord, which clearly shows, my lord, she has never attended. He has never attended the school.
I have attended, but now nowadays the school, the punching machine is there to punching machine is there to put the thumb impression, whether the but petitioner is not allowed to put his thumb in to put the thumb in the punching machine. But on after 9/5/2023 passed by this honorable court order, the petitioner was issued a show cause notice, my lord, and he has replied. Thereafter, a hearing was conducted before the director.
Just a minute, madam, now. Are you all ready for disposal or what?
Let it become immediately after view vacation,
I have the records.
and there is no need to file any.
That's what you see, if you want to dispose, it's okay. If you don't want to dispose, I don't want to hear. We're wasting time.
But issue is simple, my lord.
Okay, you are ready, I'm ready.
Yes. After the interim order passed.
No, you start from the beginning. What is your prayer in this petition?
Release of salary.
Release of salary, my lord.
Release of salary from June 2018, correct?
July 2018.
Huh?
July 2018. yeah.
From July 2000, that's what I said, July. Madam is saying June. Then you put me off track. Then I was thinking, what was I reading? Must be some other case. That's why I was not very
Page
interested.
26 is the prayer, my lord.
20
That's very important, my lord, to note that prayer.
Yes,
I'll make my submissions on 9th of May.
July 2018, my lord. And after that, my lord,
just a minute. Okay, so you are a teacher in which school?
earlier I was working as a headmaster in 112. Earlier, I have administered
1125.
1125 of Dakshin Culture Primary School.
Then you ask for mutual transfer.
Thing is that when not earlier on 2016, my petitioner and the respondent number 10, the respondent number 10, file a mutual transfer before the authority, but that was cancelled, my lord. That was
Mutual transfer application dated
dated on 21, on 15 to 2016, my lord.
15 to 2016.
16.
Then
But-
transfer order issued on
No, I am submitting, but subsequently said order for mutual transfer in respect of the petitioner and the respondent number 10 was cancelled by the department.
Madam, if it before cancellation, there has to be an order. Where is that order?
That order is not with me, my lord.
Not with you.
No.
Then from where do you say that if there is no order, what is there to cancel?
But there is an.
Was there an order of transfer issued or not?
Yes, my lord, yes, that is annexure 4 of the writ petition.
Page?
Yes. So 4 of the writ petition. 4 of the writ petition, that is 35, my lord.
Where is the petitioner's name?
Petitioner name is Dakshin Culture as a Montus Meadow, from 1, 2, 3, 4, my lord.
5.
Hmm.
And then where is the respondent number 10's name?
Respondent number 10 is below the Rahima Khatun, below the petitioner.
Where is your application for mutual transfer?
That was, I am not annexed, my lord.
Yes, not annexed.
Yes, my
Oh, you cannot, madam, you cannot play hide and seek with facts.
no, my lord.
You see, we have got, you see, to ensure, to see whether you had applied for mutual transfer or not, we have to see what you have written in your application. Now, how do we know whether you really applied for mutual transfer or you did not apply for mutual transfer?
That is why
Did you submit any application?
yes, I have already
But
submitted. an
you have submitted, but you have
application.
not annexed here.
Yes, but that was cancelled, my lord, and
How do I know where's the cancellation order? Is there a cancellation order? That is also not here. Everything that is to support your case is not here.
that's it. And after cancellation of that order, I have
Where is the cancellation order, madam? Yes, where is the application for mutual transfer?
That is what we have brought in our additional affidavit in the IML.
Additional affidavit in the IA. By the respondent number 4.
I think it's gonna go.
You are not prepared at all. This is we keep on turning pages.
Well,
But if I will file an affidavit in reply.
it's 83 minutes.
Madam, I don't need reply. You just have to give me the pages where to turn to. When you don't know the facts, there's no point. You will file a page 83.
Page 83. Of the additional affidavit in the IA.
Huh? Additional affidavit. Whose additional affidavit?
Additional affidavit filed by respondent number 4, Director of Elementary Education.
Dated 12 June 24.
My lord.
Is it?
Yes.
Page?
Page 83.
Regarding.
No, apply online apply করে তারপর
This is a chart. This is a chart.
82 is the application and their NOC to their application is 83
Okay.
with their signature. My lord. In the left hand corner, in the right hand corner, my lord will find the petitioner's signature. They gave no objection to this mutual transfer application.
Okay, 2018. Thereafter this, so this 2018. Then where is the transfer order that has been made?
My lord, it's the page 30, page annexure 4, which my senior friend has shown, page 35.
That 2016 matter.
That is a rationalization of transfer, my lord. That's not a mutual transfer.
Yes, that is of 2016.
2016. Subsequently, page 36 is the issue that the petitioner and that private respondent, they both applied for mutual transfer. and
This is
the-
26 June. Okay,
Yes.
so this is the one. So where is the petitioner here?
Here, your lordship will find it serial number 18.
And respondent number 10?
Down below, in the same serial. Because as it is a mutual transfer, their respective schools are shown against their names. my lord.
Okay, Rohima Khatun.
Rohima Khatun.
Okay.
Issue is not that the mutual transfer is cancelled or it has been done something. Like. After this mutual transfer was effective, they were supposed to join their
Join.
school. Now the respondent number 10 has been released from her earlier school. She is joining the new school.
Okay.
Now the petitioner's managing committee, they come up with some application saying that the petitioner should not be released because for the interest of that school. And petitioner remain. However, the BEO has released the petitioner on 2/7/2018.
2/7/2018.
Now, petitioner claims that after she was released, she has gone to the new school, submitted the joining report to the managing committee, and she have been continuing. But she was not allowed to sign the attendance register, and therefore a separate attendance register was maintained for her. Now, your lordship will kindly see the prayer, Miller. She is claiming, the petitioner is claiming this salary from July 2018 from her parents' school, the earlier school. Well, that itself falsified these statements, my lord, that
Okay, so she's asking for salary from a
from the previous school.
What is happening?
And there was 3 stand taken, my lord, in the affidavit, additional affidavit, saying that on so and so date I have joined, but that school has not released me, and therefore I had returned back to my school. Now, one replied with written statement which they have filed before the authority. Well, that is very interesting, my lord. Your lordship will kindly see that written statement. Page 79 of that additional affidavit. my lord.
Yes.
This is a translator. With due respect, I so and so like to inform you that I had applied for a mutual transfer with the head teacher of so and then joined in Uttar Panpara LP school on 2/7/2018. In absence of head teacher, I have submitted the joining report to the president of SNC and started my teaching, but occasionally refrained from teaching due to my physical health issues. I have not received my salary till date. I have got the attendance register of that school, my lord. The attendance register since 2017 to 2018 to till date. He has never signed.
In the transfer school.
Transfer school. And after
Anyway, she has now prayed for from the earlier school.
it can't be. But
Lordship.
the petitioner cannot play hot and cold together.
Correct.
Once if I say that I have been released from there, I have joined the new school, but again he cannot say that no, I'm continuing in the earlier school.
No, my lord, that is.
Let us see where she has said that.
What has happened after 2016, my lord, when the initial transfer order was cancelled.
2016, there was no mutual transfer order, madam.
That's a rationalization order.
There is no mutual transfer order 2016, sorry.
2018, my lord, the petitioner joined in that school, my lord, that is admitted by the BEO. I have annexed that letter, my lord, in affidavit filed by me, 2/4/2024. Lordship, kindly see the paragraph, order, my lord, where the BEO.
Yes, Mr. Kaushik, just tell me where she has said that she has joined.
Para,
4/2024.
in the writ petition, para, first writ petition, para 17.
Para 70. As he is still continuing his duty as assistant teacher in Sanskrit.
So and so, because of the pressure of the public and guardians of the school and the school managing committee, but the salary of the petitioner have been stopped from July 18. In this connection, your petitioner clearly state that he and respondent number 5 applied for mutual transfer in the year 21/9/2015, and the same was cancelled by the respondent authority in the year 15/2/2016. Thereafter, he never applied for mutual transfer, which was proved in the inquiry done by the inquiry committee, and the inquiry committee report reveals that the respondent number 10 fraudulently tried to transfer to the petitioner's school. The in charge BEO issued a release order on 30/06/2018 at 4:30 PM. Finding no other alternative, your petitioner has submitted his joining report to the president of the school managing committee of Uttar Panpara Lower Primary School. The school managing committee of 1125 number Dakshin Kaljar Lower Primary School did not release your petitioner from the school. As a result, he is continuing his duty in his school. But when the guardian of the student did not accept the joining of the so-and-so,
We listed some other days, all question of
See again.
facts, all disputed questions of facts.
disputed questions of fact.
So where should it be decided? Tribunal?
Otherwise, it's a provincialized.
Civil court. These are all disputed questions of fact, the entire thing. Okay, right, on the prayer, the parties list the matter when? You all please get ready with that. Cannot decide, it'll take some time.
Yes.
In the meantime, I may be allowed in reply to that.
List the matter after 4 weeks. In the meantime, the petitioner may file affidavit in reply.
Supposed to file an affidavit.
Yes, higher education, Mr. D. Upamanyu was there last time. Higher education. Yes, when are you filing?
Kindly pass over, Madam Milord. Mr. D. Opomani is looking after this matter, Madam. Kindly pass over. I'll inform.
Right, please, Your Lordship. Where everything is done, is the director of higher medical have also given approval. Everything is done, Your Lordship, only the payment is to be made for the medical reimbursement. Way back in 2014, Your Lordship, he went for a medical and till now it is pending. The last letter was, I have annexed at page 21 in the year 2019,
Yes, who is appearing?
and an amount of rupees 1,43,000 only.
Yes, Mr. Das.
My lord, as per last order, I think health was directed to.
That is not health and welfare.
No, he says that health department has approved.
Yeah, approved. I have
Where is the
annexed-
letter? Give me the letter.
Yes, page 16.
Hmm?
Page 15 is the typed copy, Your Lordship. 16 is quite a little, 15.
Page?
1/5. 1/6 is the original, but it is not very legible. Ex post facto,
Unreadable.
yes, 15 is I have given the typed copy, Your Lordship. Ex post facto appropriate.
Mr. Council, this is for treatment and investigation. Where is the approval of your bill?
Bill, Lordship, Lordship will find that
Yes,
page number 19.
Lordship, as per the last order, Lordship, from the health department, I have received the instruction, Lordship. Now it is for the parent department or to.
Okay, yes, Mr. Yes,
Give me some time, madam. I'll bring the instruction, madam. After vacation, madam,
huh?
after vacation, madam, I'll bring.
Right. Mr. D. Upamanu, Learned Counsel for the Health Department, has submitted a letter dated. And submitted letter number, HSG/HIGHT court. It should be High Court, actually, it's a Height Court. HIGHT court /73/2023/1719 dated 3/4/25 issued by the Director of Health Services Assam to Mr. D. Upamanu, Standing Counsel, Health and Family Welfare Department, which is to the following effect. Can you just take it, okay, from subject. Also, Mr.
Yes, that's madam.
as thus shall obtain instructions with regard to why the above amount has not been paid to the petitioner till date.
Yes.
You want to take photo? Take photo of this, take photo of this. They might want it back.
It will be given, your lordship.
After vacation. End of the, end of the month.
Obliged.
You can give that back.
Lordship, here in this matter, I have received instruction this morning, lordship. I'll file my affidavit.
Mr. D. Upamanu, Learned Counsel for the Higher Education Department, submits that instructions have been received this morning. Accordingly, he will file affidavit within
1 week, sir.
within a week. 2 weeks, within 2 weeks. This is the matter after 2 weeks.
So I appeal for the letter number 4, your lordship.
Mr.
ADAS.
Adas appears for respondent number 4. Are you filing anything?
Our affidavit is not required, your lord.
He submits that respondent number 4 will not be filing any affidavit.
Highly obliged.
Obliged, your lord.
24 and 25.
My pleasure, lordship. So in item number 24, lordship, as soon as filed your affidavit and accordingly we have filed our reply, lordship, but reply is not in our record. We have filed on 19/2, lordship.
No, you tell me what is your case?
Lordship, in the item number 25, lordship, we have filed our.
No, talk about 24 first.
Lordship, in 25, lordship, we have filed our petition seeking for minimum wages because the petitioner services was utilized from 2000, lordship, by giving only 416 rupees, lordship. And during the pendency of the debt petition, lordship, as because this honorable court has issued notice in the item number 25, the petitioner was released from the service without following any due process of law, whereas the director himself asked the deputy district inspector, lordship, to follow the due process of law. Lordship,
Mr. Counsel, come to, what about this 24?
Lordship, during pendency of the writ petition, as the petitioner service was released, we have challenged that order, lordship. In item
You
number
see, in 25, they have said that
lordship, if lordship take up the item number
petitioner is serving as a casual employee.
yes, lord.
Then,
Lordship, casual employees, but in terms of the open das case, lordship, our case is covered because from 2000, lordship, if lordship take up the item number 24, lordship, first. First, I saw, lordship, the some 2-3 documents, lordship.
okay, anyway, you want to file what?
No, lordship, our affidavit is filed on 19/2, lordship,
So,
but that is not in record. Lordship. I have checked, lordship, just now
in
it was
item 25,
24, lordship.
24. Mr.
K. Kolita.
K. Kolita, Learned Counsel for the petitioner, submits that affidavit on behalf of the petitioner, affidavit in reply on behalf of the petitioner had been filed on 19/2,
Yes, lord.
2025. However, the same is not on record. A registry to place the same on record. You also check whether it's under
Lordship,
objection.
that is lying, lordship. Just now my colleague has inquired, lordship. In the section, it's lying.
This is the matter after the case.
Lordship may fix a date, lordship, because. Hello.
Item 26.
Arrear salary.
Here, my lord,
we need some time, my lord, due to insufficient budget, my lord, the constant budget.
Mr. P.K. Bora, learned counsel for the, which,
Respondent.
for the, all the respondents,
Area salary, non-payment of area.
I know. For all,
Elementary education department.
for the elementary education department, is granted how much time?
4 weeks, my lord.
4 weeks time to file affidavit in a position. Miss,
I'm representing respondent number 5 on behalf of SK Medley.
your name,
M. Das.
Miss M. Das appears on behalf of Mr. S.K. Medi, learned counsel for the respondent number 5.
My prefer date after 4 weeks.
What is this? Where is salary? What is this?
Area salary.
No, 23, man.
Retired long back. Pension payout.
No.
Is
Area
it-
salary for which period?
That's a period of suspension.
Which period? Two 2015-16, no hurry. You file the writ petition after 8 years.
In this case, my lord, petitioner brother was working as a LDA, my lord, and he was without any family, my lord. He died, my lord. There is any specifically in respect of ZPF, any, my lord, retirement benefit, maybe give.
Yeah, how many brothers and sisters are there?
My lord, only 5, my lord.
5.
Oh, yes.
So who is to get? You go to the civil court.
So, my lord, problem is that not, they file an affidavit last occasion.
No, you
There
go
is
to
a
the civil
specific
court.
order, my lord.
Maybe
go to the-
specific order.
No. I'm sorry for that, my lord. Any settlement in outside the court. And
Huh?
now, and honorable court, 10 days, my lord. There is observation last, my lord.
Yes, what is the observation?
Observation, my lord. By order dated 10/5/2024, my lord. My lord, pendency shall not be barred for the parties to reach.
That you
and
can
out
do
of
it
the
in civil
fixed
court also.
My lord,
That you
they file an affidavit. They stated that no problem, my lord. We are in divided by all, my lord, equally, my lord. I am also specific statement is there, my lord. We take all are, my lord, by mutually, my lord. In my petition, my lord, please may kindly see the page 10 last paragraph, page 10 last. The petitioner undertake to share the service benefit of late Jitenborough with all his brother and sister in equal proportion after deducting the expenses incurred by the petitioner in various steps, my lord. And they file an affidavit. They stated that they have also no objection, my lord. They file an affidavit, my lord. Affidavit filed by this 7, 8, 19, that there are no objection and they equally benefit the share, my lord. My lord. They say that para 11, the service benefits should be divided equally between the all legal heirs. So, when directed to the authorities, my lord, they give the money by, we are undertake to equally, my lord, take the share. This is my, because of that, all my ZPF as well as are now not released, my lord. Government will, the department will consider what amount may be there, my lord, they may be divided by all chairman. This is my
Yes,
chair.
madam.
Madam, till date, madam, they have not submitted a next of kin, madam. For the
We
department.
submitted, all everything is submitted. And
Where have you submitted?
before that, this BU, Block Elementary Education Officer, man.
Why haven't you submitted here?
No, already submitted, my lord, they did not take into consideration, so thereby,
No, my lord, because the elder sister is also claiming a pension, my lord, as per the instruction, my lord. There's a dispute between the brother and sister, my lord.
It appears so. We don't know this document whether it's correct or not. As per the petitioner is the younger brother of the, he has 4 other sisters and brother also died. The officers could not release the pension due to non-submission. First, legal heirs pay pension and and they moved to court of Monsif number 2, Lakhimpur.
Okay, my lord.
that
No,
was,
there's a
that
court.
was withdraw, my lord. There
Where is that?
Yes, my
Withdrawn.
lord. Yes. Last question I have, that is withdraw, my lord.
Why is everything with you, not with us?
Petition is, my lord. So, my lord, there the my lord, instruction was submitted earlier occasion also, my lord. And honorable court called that, and they have to call, collected this. So, my lord,
Whether sister can get pension and all, there's no, I don't.
we are not coming for pension. We are coming with any service benefit. Both are equally, we are giving the equal, both, my lord, private respondent also stated that we are no objection if equally share,
So it is dismissed, it is not withdrawn.
my lord. But I was not filed, my lord. The other was filed, my lord. My fear is that, my lord, any document will be submitted before the authorities and authority will consider and any amount we are undertake that, my lord, we are
Yes, what to do? Yeah, we'll leave it up to the authorities to
my lord,
decide.
my lord, my lord.
Let them decide.
Right.
Okay. Whether they are agreeable or not, we do not know. Right, heard Mr.
And
N. Bora, learned counsel for the petition. Also heard Ms. S. Shutia, learned counsel for
1, 2, 3, and 4.
1, 2, 4. Miss
Yes, Sharma.
for 5. What about 7 to 10?
they file affidavit, my lord.
No, no, where is the council?
Council, my lord, they file an affidavit on
S. Fukan is there. Who is this S. Fukan?
they file an affidavit, my lord. Affidavit is on record, my lord, there.
Maybe shown in the public matter as to 9 money Kalita.
S. Fukan is there, name, that's all.
Part of June 2024, they file an affidavit.
Right. The petitioner is the younger brother of the late Jiten Barwa, who died on 30/01/2019 while working as an upper division assistant in the office of the Deputy Inspector of Schools, Dakwa Khana, Lakhimpur. The petitioner's case is that his deceased brother was unmarried.
Right.
What about mother and father?
Expired.
And that their mother and father have expired. The further case of the petitioner is that he has got, there is that the, that he has got two other brothers
Right.
and two sisters
Right.
who are who are respondents number 7 to 10. He submits that the respondents number 7 to 10 have submitted an affidavit dated 4/6/2024, which is to the effect that they being the legal heirs of their late brother Jiten Barwa, they are also equally entitled to get the service benefits of their late brother along with the petitioner.
Para 11 last line.
In as much as they are unemployed and were maintained by their brother. Correct?
Actually, he is-
Huh?
no issue.
But no,
My lord, actually, he's died in my residence, my lord, we are, because of,
who's resident? Your resident.
yes. And
So-
all
so-
medical, there was also expensive by me, my lord.
That is their case.
My lord, no problem, my lord. Maybe, my lord.
So, sir. Next one, the petitioner's counsel submits that the petitioner has no problem, has no problem in dividing the service benefits of his late brother Jiten Barwa equally with the respondents number 7 to 10, correct?
Mal.
Yes, sir. As such, the respondent authority should be directed to examine the case of the petitioners and the respondents number 7 to 10 for grant of the service benefits of their late brother and thereafter grant them an equal share of the service benefit.
Mal.
So, sir, next, this has to take Learned Counsel for the
Elementary education.
Elementary Education Department submits. And you also, you have 4, 5 and 6.
Accountant.
Okay, here, 1 to 4 submits that no next of kin certificate has been submitted
Submitted.
by the petitioner either in this writ petition or before the DO Lakhimpur to show that they are to show that the petitioner and the respondents number 7 to 10 are the siblings of the late Jiten Barwa. He also submits that with regard to the with regard to the service benefits of the late Jiten Barwa. The petitioner herein and his niece had moved the court of the Munsif number 2, North Lakhimpur. And as such, the issue should be decided by the Learned Civil Court. Next paragraph.
The para 7, it is mentioned, my lord, the petitioner and the elder sister both claim separately, my lord, pension.
Further, the petitioner and the respondent number 7 had claimed the pension benefits of their late brother separately. However, in the absence of next of kin certificate, nothing could be released to the petitioner. Next paragraph, Mr. N. Bora, the Learned Counsel for the petitioner, submits that the title suit bracket D. What is this? D or what? Title TS bracket D. Declaratory.
Declaration, I think I do.
Bracket D. 02/2020, which had been filed by, who is this Gautam Barwa?
Gautam is the nephew of the
Which had been filed by one Gautam Barwa against the respondent number 7 and others in the court of the Munsif number 2, North Lakhimpur, had been dismissed due to the plaintiff being absent without any step. Then who is Gautam Barwa also? Who is this? Who is Gautam Barwa?
Is the one of the sisters son.
The petitioner's counsel submits that Gautam Barwa is the son of which sister?
My lord, this, my lord, one, this,
Huh?
late Buddheswar Burwani. Let Bhutteswar Borua.
What?
Mana page 18. I'm sorry. Sister. Next of kin, there is no Gautam Borua. Page 18. As per instruction, one of the sisters son, my lord.
I don't. Whatever I said, is the son of one of the sisters. Who's that? Next. I have heard the learned counsel for the party. There, as can be seen from the pleadings, there is no next of kin certificate regarding the siblings of the late Jiten Barwa annexed to the writ petition. No,
Next of kin
before
is there.
next of kin certificate issued by the district commissioner's office
Okay. There,
in the
I
writ
annex-
petition. Huh?
I annex this one.
Where?
Page 21.
21.
Yes, 20 and 21.
What is there?
Yes, sir.
But what about the genuineness of the same? We don't know.
No, till nowadays, man, they are in their type of in computer generated copy, man. That we can keep the ID, man.
We don't know if these respondents are the true persons also. We don't know.
They will verify,
Not
man.
if
They
it-
will verify.
Why not go to civil court and decide?
The next of kin is there, man. So, man, I will put submit it and they will pass the appropriate order.
Yes, this, where should he go? What do you think, madam? Should we send it to civil court or to the authority?
Authority will consider.
The civil court,
Civil court.
because evidence will take where the civil court.
Okay, right. What do I say? No, full stop. Next, you're right. The question with regard to whether the petitioner and the respondents number 7 to 10 are the siblings of the late Jiten Barwa, and whether they are entitled to any of the service benefits of their late brother. And these are questions of fact, which, in the view of this court, should be decided by an appropriate forum. Accordingly, this court is of the view that the petitioner should approach the civil court for grant of his claim regarding the service benefits of his late brother by implementing all the other
Actually,
siblings.
they all.
The writ
Madam,
petitions
they say
accordingly.
they already not submitted the next of kin. We are submitted on that and they will decide my government. Otherwise, civil court go to and they are he was already go pilot we submitted and they verified if we are entitled, they will. Otherwise, civil court.
We don't know.
No,
As
we
Huh?
submitted on
As
documents,
per the
madam.
instruction, both are claimed separately, madam. This is the instruction from the department, madam. That's why, madam.
So they will decide your method. They decide your as per
Who
law.
will receive what portion, my lord? We do not, madam, we cannot.
Okay, whatever I said. Which has to be decided, which in the way this court has to be decided, can be decided after hearing all the parties
Mine.
concerned. Consequently, the respondents, the petitioner consequently, the respondent number, who will decide it?
The district elementary education officer.
That is respondent number
Respondent number, my lord. Number 3, my lord.
That's point number 3.
My lord.
Shall take a decision as to whether the petitioner and the respondents number 7 to 10 are the siblings of the late so-and-so
My lord.
whose parents have expired. He shall also take a decision as to whether the petitioners are petitioner and the respondents number 7 to 10 are entitled to any of the service benefits of the late Jitin Baron. The same should be done only after giving an opportunity of hearing to all the parties hearing. The next of kin certificate issued by the original next of kin certificate issued by the concerned the district commissioner regarding the late Jitin Barwa. In relation to the late Jitin Barwa, should also be submitted by the parties. The respondent number 3 shall take a decision with regard to the above directions within a period of 3 months from the date
Date of receipt,
of receipt of a certified copy of this order,
along with the petition, my lord, because
along with a copy of the writ petition.
My lord.
The writ petition is accordingly disposed of.
Absolutely.
My lord, in this case, my file an affidavit. I want to submit one short reply, my lord. Any day fixed after vacation, entire matter may be disposed of on this. At the consent. That's number 3 and 5 file affidavit.
So, Mr. Counsel, what right do you have? Yeah, what right do you have? You have been you are no more you're relieved from the post of in charge CRCC. You are reverted to your original post.
That is why entire matter will be disposed of, my lord, after.
No, now you can dispose of now. There's no point. Why should we keep it pending?
Because, my lord, in improved order, nothing has been recorded.
Huh?
Nothing has been recorded.
Not required.
No,
Not
but-
required. You don't have any right.
But lordship,
There's no, so the very, if there was something recorded, then you could have said it was a punitive transfer or something like that. But if there's nothing recorded, then there's nothing wrong.
This is not a case, my lord. My case is this, my lord.
You don't have any right.
My life is in danger.
No, life is not in danger.
I file an affidavit, my lord.
Let us see if your life is in danger. Let us see what prayer have you made. Have you asked for protection?
Yes.
You asked for
No,
protection.
your lordship kindly see my affidavit. I file an affidavit counter with page 42. Just your lordship kindly see my affidavit.
Page 42.
Yes, I filed reply to the affidavit filed by the private respondent element.
You have
Now
filed
presently
reply.
he is not a headmaster, my lord.
Maybe.
Page 42, your lordship kindly see.
Page 42. Yes.
Then your lordship kindly see.
Affidavit filed by point number 11. Yes.
Then your lordship kindly see page paragraph 5.
Paragraph 5. Yes.
reply.
Anyway, this is different thing. Who is this respondent number 11? He is a private person.
Private respondent. That is why your lordship kindly see. My life in there, page 58, your lordship kindly see.
Page 58.
58, annexure B. My lord, I lodged an FIR on the basis of said FIR and.
Page 58 is attendance sheet. Yes.
And then the matter has been referred to the executive magistrate, executive issue notice, that is the notice. Illustratively page 58. This is the
Yes.
notice issued to them, my lord. Then matter was finally heard. Page 59, my lord.
Page 59, these are all charts. What 58, 59? What are
Page 50, 59, my lord.
59 is bond.
So, wrong mark has been given, I think. my lord. Affidavit filed by
If mine
counter
is
affidavit.
wrong, yours is right. What to do? I cannot chase after you
Hello.
and paginate
My
my
lord, sorry, my lord.
copy with yours.
I am sorry, my lord. Page 59, this is the affidavit reply.
Lordship, kindly produce my affidavit. He was irregular, Lordship.
Para,
Para 4, page 22.
para 4, page 2,
Page 22.
page 22.
Yes, Lordship. Filed by the Director of Education.
Madam, why don't you all paginate your affidavits in terms of the court pagination?
Yes, Lordship, my,
There is a wrong presentation. I will.
Just a minute. No, just a minute. Yes.
my affidavit is filed by the JP Brahmo, Lordship. This number,
Your affidavit filed by,
JP Brahmo,
huh?
JP Jagat Prasad Brahmo, Director of Education.
Who is this counter affidavit filed by writ petitioner?
Counter affidavit.
Azhar Rahman, who is Azhar
Yes,
Rahman?
I am the petitioner.
Yeah, and you're saying counter affidavit.
Yes, this is the counter affidavit, my lord. And that counter affidavit, my lord, annexer, he lost of kindly.
Should be reply affidavit, not counter affidavit. Yes, where is your affidavit, madam?
My affidavit, my pagination starts from page 28.
Huh?
My page number starts from page 21. If I'm
21.
start from page 21.
Yes.
Yes. Paragraph, Lordship. 4, 5, and 6, I have explained, Lordship.
I am not holding the, also intercept to holding the push of shares. Let them relook me. I have not this matter. But your lordship kindly says before passing of any order, I want to place something before your lordship, kindly allow me.
There's nothing wrong. You go back to teaching. That is
Correct,
your main job.
Correct, my lord. Your lordship kindly see their affidavit place 44, 41.
Yes.
What is what wrong designation is given? Their affidavit, my lord. Actually, designation is not correct also, my page 41, annexer E.
Legal.
I am interested to go back. Yes. I am also not interested to holding the shares of shares, my lord. By extra burden, my lord. You also kindly see now.
If you are not interested to hold the charge, okay, good. I'll record that.
No,
I will record that.
No. You also kindly see now my representation is also kindly.
No. He has not left.
And no. You also kindly see
No.
my representation, my lord. Just
No,
moment,
right.
just for a
Right,
moment.
mister.
My lord.
You can go to the division bench, Mr. Counsel, if
My
you're
lord,
not happy.
just a moment, you also kindly see my representation, annexer
Yes.
1, annexer, my lord.
Yes.
Page 16. Just for a moment.
Yes.
Page 15, my lord.
Page 15.
Yes.
Yes.
My representation.
Yes.
With this respect, I beg to state that I am Isaac Rahman Swensu. You have knowledge about the happening in the Indian Swensu after this Thursday. For that affair was lost at Kajago police station, so it is very difficult on my part to attend the said school and take classes. It is therefore begged that owner may kind enough to accommodate me to classes at Malikpara Swensu School or any other schools, my lord. Now you will kindly see on the original one, my lord. Original page 16. On the body of that application, they accepted and permitted. I may be permitted to take classes another schools. I am continuing attending that classes. Now, my lord, there is a
No,
letter.
this is a different thing.
And my lord, there is a now page 41, my lord. My case is under consideration that I may be my treatment may be considered. My lord. Only that
for the
observation
petitioner.
I may be transferred to. I may only that page 41, my lord. Because I will be killed, my lord. That is why magistrate asked them to give a bond. 10,000 bond has been executed by the applicant, my lord.
You'll be killed. Why?
Because, my lord, the original headmaster of that school was placed under suspension. They think that I am the person placed him under suspension.
I heard Mr.
Then
Jayamat,
they
Senate
accept
Counsel
me,
for
my
the
lord.
petitioner. Also heard Ms. R.
Page 41 only also
for the
consider, my lord,
CTC.
there everything, my lord.
Hearing concluded. Mr.
And for the S1 11,
Mr. BK Deca appears for the respondent number 11. Mr. Aosin appears for respondent number 10. Ms. S. Tuti appears for. Hearing concluded, judgment reserved.
Only my lord, page 41 may be considered, my lord. Well, my statement, my lord, not in this, that may not be recorded, my lord.
Wait, please.
Yes.
Lordship, by page 66 order, at page 66. The managing committee of the petitioner was put on hold, Lordship. Kept in abeyance, Lordship. Till an
Yes, what has happened, madam?
In this case, madam, we have filed our affidavit, madam. In para 3, madam, page 73, madam.
Yes.
Second para, madam, it is pertinent to mention that the district elementary officer approved the newly constituted SMC for 699 number to visit LP school on 5/1/2024, madam. But a complaint was filed on 2/2/2024 before the DEO Dhubri. Accordingly, a hearing was held on 17/2/2024. Thereafter, the DEO kept in evidence the approval of the 5/1/2024 and asked the DEO education officer Golagganj to inquire into the matter in regard to the formation of SMC number of 699 number LP school. Further, it is stated that as per the report of the DEO Golagganj, a hearing was conducted on 4/10/2024, where the petitioner along with the headmaster of the so-and-so school and SIS of Golagganj and the concerned CRCC were present. It is further stated that in the said hearing, the headmaster of 699 number of Citra LP school and the CRSC have submitted written report in regard to the function of the SMC, and after going through all the documents, it was found that the SMC was not constituted as per guideline. Therefore, it was decided till the formation of new school and ad hoc SMC would be constituted to run the function of the so-and-so school. Till date, the ad hoc SMC continuing the function of the 699 Usitra LP school, madam. Because of the interim order of this court, my lord, no new SMC has been constituted.
No, what do you mean it has not been formed under as per guideline? It's what do you mean? As per, how is it not formed as per guideline? Which guideline?
This is the report of page 76, my lord.
Huh?
Page 76, my lord.
76, yes.
And this is the inquiry report, my lord.
Yes.
With reference to the subject cited above, I have the honor to inform you that as per memo number so-and-so dated 11/9/2024, SI of school Golagganj Education Circle number 1 has entrusted the inquiry. The fact of 699 Usitra LP school in connection with the SI of inquiry and submitted a detailed report where stated that the school SMC of so-and-so school is not constituted as per guideline. But madam, they have not mentioned under which guideline, madam.
That is what. It's like saying that, you know, he's charged with the offense under the IPC.
Lordship,
What is that? Which IPC? That, how can it be?
My lord, may take it after Bihu vacation. I will take instruction under which guideline, my lord.
Lordship, may kindly peruse page.
Where is the inquiry reports?
Nothing, Lordship.
Huh?
And as per guidelines, the DO has to pass a reasoned order, Lordship. dissolving my committee, then only a new committee can be formed, Lordship. There is
My lord,
nothing,
new committee
Lordship.
has not been formed till date, my
No,
lord.
no,
Because-
your committee has not been approved, so the question is
My
formal.
committee has approved.
Huh?
That committee was approved, my lord.
Approved,
Thereafter,
Lord.
my lord,
Approved.
complaint has been received, my lord.
Okay, show me.
Yeah,
That
pa-
notice, that notice
Lordship.
has to be given.
Page
That no
49
notice was given to you.
Page 49, Lordship.
Page 49.
Is the approval of my committee, Lordship.
Page 49.
Lordship.
Approval of school, approval order of constitution to the managing committee census approval of the census. So approval has been given
Lordship,
by the
by the DO.
DO, my lord. Approval was given on.
by the DO.
My lord.
Under what provision?
Lordship, we have annexed the guidelines, Lordship.
Show me the guidelines.
Lordship. Page 27 of my read petition. It start from page 26, Lordship.
Yes, show me.
Relevant portion, Lordship, page 27. Roman number 5.
Yes.
The district elementary education officer, after examining the resolution, shall approve the name of the person as president and other name person as the vice president out of the names of two persons selected, elected by the parents of the guardian for the purpose.
So right here, the petitioner is there are 10 of you all.
Lordship, they are the president as well as members of the managing committee.
So this five talks only of approval of president and the other person is vice president.
Lordship, as per this provision, Lordship, page 49 has been approved.
No, but where is the approval required for the other members? For the entire SMC, where is the approval required?
Approval required for the constitution of the SMC.
Yes, where is that?
That Roman number 5, Lordship.
5 is only for president and vice president.
My lord, it is in page 22255, my lord, of this group, my lord.
255.
Thirteen one, my lord.
Who will give the approval?
District elementary education officer.
It's only for president and vice president. What about the other members?
Other
Not,
members are
not required to give approval.
Not required, Lordship, because they are selected by the parents, guardian level in the meeting, general meeting.
No, it says the selection of the president, vice president, and members of the SMC shall be made by the parents, guardians. Everyone is by this.
We have annexed the Lordship meeting, minutes of the meeting, page 35, Lordship. Page 35 is the general meeting.
I am on the question of why is approval given only for president and vice president? Why is approval not given for the other members? So along with the names of the members as per resolution,
Lordship, page
Page 47. my lord.
47.
huh?
Page
Page
47 is the proposal, my lord. Repetition, my lord.
So 5 talks about other members also.
Yes,
Page 47.
all the members, sir. Including the member secretary, this is the headmaster.
So it has been approved.
Lordship.
Thereafter,
So now where is the notice for dissolution? What is the procedure for dissolution?
Lordship, page. We have annexed the guidelines, Lordship.
Removal of president, members of SMC and fitting of
Lordship, page 28, 29. Lordship, 6 Roman 3, Lordship.
Yes.
While receiving complaint against a SMC from community, organization, government official regarding non-compliance of government order, instruction, negligence of duties and responsibilities, non-cooperative of implementation of government funded schemes for the improvement of the school, the district elementary education officer will institute an inquiry into the matter and subject to the authenticity of the complaint shall pass a reasoned order for dissolution of the SMC concern. Lordship, by the impugn order, Lordship, they sought to dissolve my committee without dissolving my, they sought to constitute a new committee without dissolving my committee. That is my case, Lordship. Lordship, may kindly have a look page 69 for a moment.
Till now, they have not dissolved your SMC. Have they
No.
dissolved? No. And anyway, some notice has to be given to him.
There is no mention of any inquiry, no mention of any reason order, nothing.
Okay. I think, yes, madam.
my lord.
I think, yes, right.
My lord, if you lordship peruse page 77, my lord,
77.
my lord.
Yes.
This is the, my lord, enquiry report, my lord.
Huh?
Submission of enquiry and visit the this is the enquiry report. my
And
lord,
this
that
is the inquiry report.
My lord.
Is not constructed as per guideline. What is?
And Lordship, there is no
My lord,
mention of any inquiry in the impugn order itself. There is no mention of any
Impugned order is page?
69, Lordship. Is the type copy and Lordship 71 is the original. Lordship. In continuation of office order number so and so dated 23rd of February 2024. Now, Lordship will see page 67 is the 23rd order, Lordship. In continuation, there in between nothing is there.
Nothing is there. Yes.
Lordship.
My lord, page 79, my lord, this is the complaint given by the, my lord, headmaster, my lord.
Because that very headmaster has submitted the proposal, Lordship. Now, how could he submit the proposal if my committee was not?
My lord, as per 13(1).
No, madam, whatever it is, you see, whether there is a, so 79 is what?
79 is the complaint, my lord, given by.
Is not constituted as per the guidelines. Okay, but it has been approved. Rightly or wrongly, it has been approved. So they are the school management committee as on date. Now, if it is a school management committee, unless it is dissolved, how can they be ad hoc committee? Unless the school management committee is suspended or dissolved, how can someone else take his place? And to take his place, some form of notice has to be given to the petitioner prior to taking action upon it.
The complaint was received against that committee, my lord.
Correct.
And
Can
hearing
you-
was also conducted.
Can you condemn a person unheard? Then that is what I'm saying. Right. Heard Mr. R. Islam, learned counsel for the petitioners. Also heard Mrs. Tutia, Learned Counsel for the Elementary Education Department. Then this order dated 25/11/24, huh? No, no, don't say that, that's right. It is the case of the petitioners that in the general meeting held on 25/11/2023, in respect of number 699 Uchita LP School, comma, a new school management committee consisting of the petitioners hearing was constituted, comma, with the petitioner number 1 as the president. Full stop. The newly constituted school management committee now the formation of the newly constituted school management committee was sent to the district elementary education officer Dhubri for approval, and the same was granted by the said authority on 5/1/2024, correct?
Lordship.
Just tell me the facts, huh, if I'm wrong. 5/1/2024. In terms of Rule 13(3) Roman 5 small of the Assam right of children, right of child to free and compulsory education rules, comma 2011, hereinafter referred to as the 2011 rules. Good stuff. Next paragraph. In the meantime, the headmaster of the said school submitted a complaint on 28/11/2023, correct?
No, Lordship, complaint was submitted by one Shahalam.
Okay, in the meantime, one Shahalom Bepari, SAHALOM, BEPARI, Bepari, submitted a complaint on 28/11/23. Page
57.
stating that the SMC had been constituted in violation of the rules thereafter.
Page 60.
There was a 29/11/23 meeting. No, thereafter, the district elementary education officer Dhubri issued a communication dated 29/11/23 to the Block Elementary Education Officer, Golakganj, CRCC, the CRCC, and the head teacher of number 699 Uchita LP School, and to the complainant to have a hearing on 30/12/2023. Sir. Thereafter, the District Elementary Education Officer gave its approval of the newly constituted School Management Committee of the number 69 Uchita LP School on 5/1/2024, comprising the petitioner's hearing. Sir. Next paragraph.
Page 66.
The said Shahalom Bepari once again filed a complaint on 2/2/24 before the District Elementary Education Officer, new paragraph, Dubri. And a hearing was held on 17/2/2024. Sir. Thereafter, the District Elementary Education Officer, DEO, DEO, kept in abeyance the approval, the letter dated 5/1/2024, by which approval for the SMC had been accorded. While order dated 21/2/2024. And till the outcome of the inquiry report on the formation of the petitioner's SMC, and on the formation of the SMC, made on 25/11/23, was concluded about the said SMC was kept in abeyance. Now, the approval letter dated 5/1/2024 was kept in abeyance. The order dated 21/2/2024 also stated that till the outcome of the inquiry report was made, an ad hoc committee was constituted for 3 months for running the school management, the school administration. Good stuff. Next paragraph. The petitioner's counsel submits that once a SMC has been constituted and given approval by the DEO in terms of Rule 13(3)(5) of the 2011 rule, an ad hoc SMC cannot be constituted unless the earlier SMC is dissolved or kept in suspense, or is suspended. Further, The petitioners have not received any information till date with regard to the outcome of the inquiry made against the formation of the petitioner SMC. So as to allow the continued extension of the ad hoc SMC. Full stop. Next paragraph. Ms. S. Tutia, the learned counsel for the Elementary Education Department, submits that though the though the DEO had approved the newly constituted SMC, petitioner SMC, complete, comma. An ad hoc SMC had been constituted due to a complaint being filed against the petitioner SMC on 2/2/2024. After a hearing was held on 17/2/2024, the DEO kept in abeyance the approval dated 5/1/2024 and asked the BEO Golakganj to inquire into the matter regarding the formation of the petitioner SMC. She submits that in terms of the report of the BEO Golakganj, a hearing was conducted on 4/10/2024, where the petitioner, along with the head teacher of the school and the concerned CRCC, were present. It was thereafter found that the petitioner SMC had not been constituted as per guidelines. As such, it was decided that till a new SMC was formed, an ad hoc SMC would be constituted to run the school. I have heard the learned counsels for the parties. As can be seen from the submissions made by the counsels for the parties and the averments made in the pleadings of the parties, the formation of the petitioner and SMC had been approved in terms of Rule 13, bracket 3, bracket Roman 5, small, of the 2011 Act, and approval had also been given for the same. No, just say had been, approval had been, just read it, just read.
According.
No, add approval cut. Full stop. Thus, for all practical purposes, it was a regular SMC. Full stop. However, the state respondents have now taken a stand. Before that, Rule 13, bracket 3, bracket 5 of the 2011 Act rules is hereby reproduced herein below as follows. Page 257. Next paragraph. In view of there being a regular SMC, it was incumbent on the state respondents to be able to constitute an ad hoc SMC to replace the existing petitioner SMC, only after the petitioner SMC was dissolved. No, cannot be. It was suspended. The approval was suspended. So what is wrong?
No, it should be dissolved only to constitute a new committee, Lordship,
No,
Yes.
just a minute.
by page 7.
What have I said? No, cut that. Next para. The next para, the letter dated 20/09/24 issued by the BEO Golakganj to the DEO Dubri is to the effect that as per his inquiry, the petitioner SMC has not been constituted as per the proper government guidelines. And as such, a request had been made to take necessary action as per inquiry report so as to solve the problem of the school. The DEO Dubri thereafter issued an order dated 22/10/2024 stating that no, this is not.
Lordship, page 17,
Huh?
new committee directed to be constituted.
Where page
70, Lordship.
70?
70, serial number 4, Lordship.
70. Okay.
The Bolok Elementary Education Officer, Golokganj for
What have I said? Just read the last. The DEO Dubri thereafter issued the order dated 22/10/2024. Correct? Whereby it directed the BEO Golakganj to instruct the head teacher come member secretary of 66 number Uchita LP school to constitute a regular SMC of the school within 3 months as the further extension of the ad hoc committee would not be made. On considering the above letter dated 22/10/2024, it is quite clear that a new SMC is sought to be constituted without dissolving the earlier SMC or cancelling the approval given for constitution of the petitioner SMC. Next para. In terms of Rule 13, bracket 5, no, bracket 6, bracket Roman 3, correct? Roman 2, no, Roman 2, Roman 2. No, no, just say the 3 bracket 13 bracket 6, bracket 6 of the 2011 rules, comma. A recommendation for dissolution of the SMC can only be made after an inquiry is conducted. Into the complaints of negligence of its duties and responsibilities. And that, now full stop, further. On the basis of the inquiry report, the SMC concerned will stand dissolved from the date of the order of dissolution made by the DEO. In the present case, comma, there is nothing discernible in the inquiry report or in the impugned order dated 22/10/2024 as to the specific violation of the 2011 rules while forming the petitioner SMC. The respondents have only taken a stand that the petitioner SMC had not been constituted as per the guidelines, correct? As per guidelines. The same is, however, bereft of any specifics. It is like saying that a person is charged for the offense of an offense under the Indian Penal Code without specifying which particular provision has been violated. Further, it is not the stand of the respondents that a copy of the inquiry report has been furnished to the petitioner.
Well, he was present, my lord. He has stated, my lord.
Where?
In the page 74, my lord.
Page 74.
Further, it is stated that as per the report of the DO Gulakan.
Page 74.
74, my lord.
Where?
Further, it is stated that as per the report of the DO Gulakan, a hearing was conducted on 4/10/2024, where the petitioner along with the headmaster, he was present, my lord. No.
Okay. So you have been heard.
No, Lordship. Lordship, there is.
But where is the notice?
Notice nothing, there is no signature. Even only CRCC and headmaster is there and no one else, Lordship. It is surprising, Lordship. Because they have manufactured this document.
Full stop. What have I said? Full stop. Next para. Though. Head page, madam.
74, my lord.
Though. It has been stated in paragraph
Three, my lord.
3 of the affidavit in a position filed by the Director of Elementary Education that the BEO Golagganj had conducted a hearing on 4/10/2024 where the petitioner was present. Comma. The same has not been backed up, has not been supported by any document. There is no written notice issued to the petitioner, to the petitioners regarding any steps to be taken by the respondents to resolve the SMC. Further, the petitioners' counsel has vehemently denied that the petitioner had been called for any meeting by the BO or had participated in any such meeting. Stop. On considering the fact that no written notice has been issued to the petitioner, and no notice has been given to the petitioner regarding the allegation regarding any negligence of the petitioner SMC in relation to its duties and responsibilities, or with regard to the formation, the alleged illegal formation of the SMC in violation of the 2011 rules, comma. This court is of the view that the decision by the respondent authorities to constitute a fresh SMC without the dissolution of the present SMC is not sustainable. Accordingly, in view of the reasons stated above, the impugned, where impugned, page
66.
impugned order dated 21/2/2024 and 22/10/2024 issued by the DEO Dhubri are hereby set aside. The writ petitions accordingly allowed.
Obliged.
In this case, even I am appearing for private response number 4. I am the in-charge headmaster of this, and my in-charge headmastership has been challenged by the petitioner. My affidavit is waiting, I'm just 1 week time, I'll file this.
3 times they have taken time, my lord. Otherwise, he is not having the qualification of B.Ed for holding the charge of the headmaster. That is the ground of the challenge.
You do have B.Ed?
My lord, something, my lord. Your lordship, I can see, my lord, page number 18 of the petition, my lord. I am senior to the petitioner.
Huh?
I am senior to the
No, I'm not on that. I'm only asking you, do you have B.Ed?
No, my lord, I don't have B.Ed. I don't have B.Ed.
Yes, senior, that's all.
My lord.
Any judgment?
My lord, Jagannath Pegu, my lord, 2007 3 GLT 389.
And I have one, my lord.
Yes, what? Show me.
I have one.
What
my
does
lord.
it say?
My lord.
What does it say?
My lord, I have one of our High Court, my lord.
Yes, naturally, I hope so.
My lord, in WPC 712/2022, my lord, and the settlement. However, this court cannot lose sight of the settled position of law that an ad hoc employee, ad hoc, my lord, ad hoc employee cannot be replaced by another ad hoc employee, and he can be replaced only by another candidate who is regularly appointed by following a particular procedure.
A different issue. Altogether different issue.
My lord. And my lord, and the process of appointment.
We are talking about how to make masala dosa. not tandoori chicken. Slightly different.
But I may kindly be allowed just 1 week time, I'll file, Mayor.
Arre, what is there? When you don't have that's for headmaster of the school.
In church, my lord, in church.
Maybe. But what is that rule?
Rule 14 of 2018 rule, my lord.
Rule 14,
Page 35, my lord.
35.
Yeah.
This one?
Yeah.
Page 35.
Yes, boss.
The rule 14(1).
Ah, 14(1).
That is not applicable, my lord, only in case of appointment of regular headmaster.
So this for high school.
Yes,
High school.
So he must be BT BEd. That end of the matter. Give me the judgment.
that copy is not, citation is there, my lord.
What is the citation? Long order? Is it not very long? No?
Order, my lord.
Huh?
2000,
Short, no?
short order. 2007 3 GLT 389. Yes.
Yeah, you have got 10 years teaching experience.
Yes.
Everything is there. So both of you, everything is there except he doesn't have BEd.
My lord. Page 18, may kindly see, my lord, page 18.
18.
The seniority list of the school, my lord.
Seniority, okay, you're senior. That too we accept. No,
That you are
no
not.
denial. That too you're senior.
And my lord, at the time when I was, my lord,
Huh?
when I was made the in charge, he was not available in the school, my lord. He was on deputation.
Not available.
Yes, my lord, he was
She was in deputation.
on deputation.
But her substantive post is there. Doesn't her chappals are still in that your school. Body might be somewhere else, but chapel is still there. She retains a hold in a substantive post. Okay, where are we? Yeah.
There are 9.
There are 9.
90.
Out here slightly the other way around, but it means the same thing earlier. Yes. Who is for the other side?
Secondary.
Now it's very clear now, but the time when the post fell vacant, that's the point of time it has now worked out.
So you corrected now. Now she has come back from wherever she was. She or he?
He.
It's he also he.
Both are he.
No point your affidavit. You're just wasting time. Heard Mr. B. Prakasta, the counsel for the petition. Also heard Mr.
Yeah,
B. Kaushik for the respondent's number
Secondary education.
for the secondary education
1 to 3,
department.
my lord.
1, 2, 3.
Also heard Mr. A. R. Tarukdar, learned counsel for the respondent number 4. So, Mr. Talukdar, you were vehemently opposing the representation to be decided by the authorities earlier.
No, I'm not opposing, my lord.
Out here it is recorded.
And then your lordship may kindly direct the director, secondary education, my lord, to dispose of the representation.
What do we do, Mr.?
Your lordship will decide, my lord, with mandamus direction.
That means some more time will be taken. Okay, right. The petitioner's grievance is that on the retirement of the earlier headmaster,
Yes.
the respondent number 4 has been allowed to hold the charge of headmaster of Chandpur Public High School in the district of Kachar. The petitioner's grievance is that though the respondent number 4 is senior to the petitioner as a graduate teacher, the petitioner, the respondent number 4 does not have a B.Ed degree. As the petitioner, as such, the respondent number 4 cannot be considered for appointment to the post of headmaster in terms of rule, in terms of the Assam Secondary Education Provincialized Schools Rules 2018. Rule 14 of Rule 14. Here and after referred to as the 2018 rule. Next para. The petitioner's counsel submits that the petitioner, on the other hand, is having a B.Ed
Yes.
B.Ed qualification besides being a graduate teacher for 10 years. As the petitioner is eligible to be appointed as headmaster of a school in terms of the 2018 rule, the petitioner cannot be overlooked for the post of headmaster of the said school by a underqualified candidate. In this respect, he has relied upon the judgment of this court in the case of Gopal Koch versus State of Meghalaya. No. Sorry. 389. Relied upon the judgment of Jagannath Pegu versus State of Assam and others, 2007, PGLT 389. I have heard the learned counsel for the parties. Wait. He accordingly submits that the appointment of the respondent number 4 as in charge headmaster should be set aside, and a direction should be issued to the respondents to appoint the petitioner as in charge headmaster of the school. I have heard the learned counsels for the parties. In the case of Jagannath Pegu Supra, this court was to consider a case wherein the petitioner therein, who had a B.Ed degree and had acquired 10 years teaching experience as a graduate teacher, had been overlooked for the post of, for holding the charge of headmaster of a school by a person who was junior to the petitioner therein. It was in that circumstance, it was in the facts of of that case that this court had held that it is too fundamental to state that a candidate eligible in terms of the relevant rules for promotion to a post on a regular basis cannot be overlooked for the purpose of any temporary arrangement concerning the post as in the instant case. There is another judgment. There is an order of mine, more to the point. Earlier I have made. Exactly on this point. Recently also I have made. Whereby that person did not have the BA degree. Out here, he did not have BEd out here. In Jagannath Pegu.
Jagannath Pegu case was dismissed, I think, well, other person was allowed to continue, I think.
So then how does it help you?
Because he was not the qualified person, my lord, and
Where in Jagannath Pegu?
yes, and he was the senior most. And he
Wait, where is that? That's what I'm looking.
The professional qualification side, otherwise
Yes,
he's an MA.
out here also he did not have BEd.
yes.
But here in the case, my lord, phone number 4 is an MA, my lord.
Maybe, unless you have a bachelor in education, then you cannot.
Well,
What if I just read from the beginning? Just a minute. Just read. No. No, from that, in the case of. And by person a junior therein, and who did not have a B.Ed degree. Then carry on reading. This court had thus held that. No, full stop. No, full stop. Though, no, the above observation, this court also further held that in view of the petitioner therein having the academic qualification to be considered for appointment to the post of headmaster as per rules, which was lacking in the respondent number 4. It held that the petitioner's case, the petitioner should be considered for holding the charge of headmaster There is. Next para. In the present case also, the petitioner is having B.Ed degree, while the respondent number 4 does not have a B.Ed degree. Though the petitioner is junior to the respondent number 4, the petitioner having the academic qualification, comma, the observation made by this court in Jagannath Pegu is attractive, as it cannot be said that an unqualified candidate, comma, though senior, cannot be overlooked for the post of, for holding the charge of headmaster. Next paragraph. Though the other point raised by the respondents' counsel was that at the time of the respondent number 4 being given the charge of headmaster, the petitioner was on deputation. The fact remains that the petitioner was a B.Ed degree holder, and on coming back to his substantive post, he had to be considered for the post of headmaster, keeping in view the fact that the petitioner was eligible for appointment to the said post, which was not the case of the respondent number 4. This paragraph. In view of the reasons stated above, this court is of the view that the impugned order dated
Annexure 7,
Page 26.
30th January 2023.
30 January 2023 is not sustainable, as the petitioner, as the respondent number 4 does not have the academic qualifications to be appointed to the post of headmaster. Accordingly, the said notification is set aside. The respondents are directed to consider the cases of the petitioner for holding the charge of headmaster and take a decision on the same within a period of 2 weeks from the date of receipt of a copy of the document. The writ petition is accordingly disposed. Acha, one thing you write in his submission, you write the counsel for the respondent number 4 further submits that the petitioner was on deputation at the time of the respondent number 4 being made to hold the charge of headmaster of the school. Acha, one thing also you write. Rule 14 bracket 2, na? 2 of the 2018 rule states as follows. Page 36.
Of this.
32.
Well, here I got the paragraphs comment. What has happened is, my lord, they have completed the, my lord, P5 course. Well, my lord, while having their registration in the Assam Pharmacy Council, they have objected to one point that, my lord, physics, chemistry, maths is my lord, mandatory required for that particular course. In the present case, my lord, 2 petitioners, they have not passed in, my lord, physics and chemistry. So on that ground, their registration was rejected.
So how many petitioners are here?
3.
3. So one can be given.
No, madam. In fact, two failed in chemistry and 1 in physics.
Yes.
May I please your lordship?
14, 15, 16.
Then you file the affidavit.
I will file my affidavit.
Mr. B. Gogoi submits that he has received Sarawai's comment. He is accordingly granted 2 weeks time.
Well,
File-
immediately after vacation. I will
And
file.
2 weeks time to file affidavit. This is a matter after 2 weeks.
I will rely on judgment given by Honorable Supreme Court. I will share with my.
But let him file his affidavit first.
Okay.
My lord, I am appealing for respondent 3 and 6, my lord, the principal and governing body of the college, my lord. 3 weeks time may be granted for filing everything.
Mr.
S. Raman.
S. Raman. appearing for
Respondent 3 and 6,
the point number 3 and 6 is granted
4 weeks time, my lord.
4 weeks time.
My lord, I have an objection, my lord, because my lord, the case related to the pension, my lord. I have no grievance with them, my lord. They simply need to forward my cases to the my lord state government. They are not forwarding.
Why not forwarding?
Actually, many financial irregularities have been done, my
Huh?
lord. Many financial irregularities have been done, my lord.
Oh, they-
There is
everybody-
4 weeks time to file affidavit position. This is the matter after 4 weeks.
How about that?
34.
May I please, your lordship? Lordship, here the petitioners were working as a temporary lecturer in the various polytechnics, my lord. And they were appointed by the principal after proper.
So did you took part in the advertisement
There is no
30, 12, 24?
24, yes,
You took part.
participated, my lord, result one, petition number 3 has already been cleared. In 4 is already been cleared, my lord, that you can.
Yes, what is to be done?
What happened, my lord, in this regard, my lord? We have filed affidavit, my lord, the stand is that.
No, you have filed affidavit.
Yes. Their case is,
Affidavit reply of the file.
yes, reply also filed. He is the reply, my lord. Like, he is the reply, my lord.
There's no time now.
My lord, then the Thursday,
No, not this week. I've got no
or
time.
immediately after vacation.
No time especially. You can try your luck on Friday if you want.
Friday.
This is a matter of Friday.
Oblige, your lord.
Wait, please, your lordship.
Yes,
On the last occasion, my lord, the council was directed to obtain instruction, my lord, on the page 41.
probably they have not obtained instructions. That's why they are nowhere to be seen.
I can inform that they are there.
What to do? Third financial upgradation, benefits of the third financial upgradation.
I'm for the AG, my lord, perhaps we have little to say in this matter, but your lordship may not record it as of now, but what I gather from the petition is that we may not have much to say.
Who is for the,
Here.
Then it's September.
you received instruction?
Probably the director of pension has to take some steps, my lord.
Pension?
Director of pension. Lordship will see para number 3, my lord, the reply to para.
The petitioner had been allowed to draw third MA CPS.
Yes. That benefit has not been given by. That is the only. In this second paragraph, the sentence starts from but my lord, but the
Huh?
revision due to, in the second paragraph, my lord, you can see,
Yes.
para 3. As reported by the DO Kamrup Amingaon by its later dated so-and-so petitioner had applied for a commutation of pension and DO concerned had submitted the proposal to the Director of Pension through Kritagata portal on 1/8/2023. The petitioner has already received the commuted value of the pension through Treasury Officer Kamrup, but the revision due to commutation has not been updated on the Kritagata portal by the concerned authority that is Director of Pension, due to which revision due to MSCPS could not be submitted by DO Kamrup through Kritagata portal, as the next revision proposal could be proceeded unless the completion of the procession of the procession of the previous revision. So the Director of Pension has not updated the.
So,
Yeah.
so if it's not updated, not given, basically.
Once they do it, we can send it to proposal again, man.
Who is the director of pension?
This one was 6 months. Yes, government.
Who is appearing?
Government.
Okay, right. Heard Mr. I. Shakil, counsel for the petitioner who submits that though the petitioner had been allowed to draw the third financial upgradation under the MACPS, the petitioner has not been given the benefits provided therein. Full stop. Next para, Mr. B. Kaushik, the learned counsel for the
Elementary.
Elementary Education Department has submitted a letter dated 5/4/25 issued by the Joint Director of Elementary Education Assam, along with a para-wise comment which states that though the petitioner had been allowed to draw the third MACPS, comma, but allowed to draw the third MACPS, comma, the petitioner had been allowed to receive his pension by way of commuted pension. However, the revision due to commutation has not been updated on the Kritagyata portal, KRITAGYATA portal, by the Director of Pension, Assam, due to which revision due to MACPS could not be submitted by the DEO Kamrup, Amingaon. Pusta. Mr. Who is appearing?
GPEGU was there.
For the Director of Pension?
GPEGU was there.
Mr. G. Pegu, learned counsel for the Director of Pension, shall obtain a status report with regard to whether the revision of the petitioner's pay due to the third MACPS regarding petitioner's commutation of pension has been updated on the Krita Gyata portal by the next day.
I'll inform.
List the matter on.
The petition looks like it's.
Naturally. After in May. Mr. Bhattacharya appears for?
Five.
Mr. A. Bhattacharya, no? D. Bhattacharya, and Miss R.M. That's point number 4. Mr. Deary, you're there? For Director of Pension?
Yes.
Okay, instead of Pegu, you write Mr. B. Deary. You have to obtain instructions as to why the commutation has not been updated. His pay has not been updated in the portal. Will you please give him a copy of the letter?
I have to send.
Yes, send it. Huh? You give one to him also. It's all WhatsApp, so
Yes.
no cost.
Mr. Dury relies on words.
Your Lordship, may kindly see the last order. 18 months.
Yes.
Here, my lord, on the last occasion, I have flagged that much, the green flag. We produced the instruction, my lord, that on 4th of March, a hearing was called for, my lord. We are awaiting the report on that hearing.
Mr. B. Kaushik, Learned Counsel submits that a report with regard to the hearing held on 4/3/2025 with regard to the claim of the petitioner for arrear salary has been held. No, has been called, is awaited. List the matter
After vacation.
after vacation to enable Mr. B. Kaushik to produce the decision taken in the meeting.
A date may be 24.
It may.
Thirty-seven to 40.
Here, my lord, we were granted time to.
Huh?
We were granted time to bring a record, my lord. I need some time, my lord. I'm not able to bring, my lord.
On the prayer of Mr. PK Bora, who pray for time to produce the records, list the matter after 3 weeks.
God bless.
Lordship will give us 3 weeks time to file our affidavit.
Okay.
My lord, my lord, my lord, you can file a between in main case, but the thing is this, my lord, while we moved in repetition, by mistake, the interim pair was not made.
Huh?
By mistake, by our mistake, interim pair was not made. Consequently, see the repetition. At page 18. There was no interim prayer by mistake. The Honorable High Court of Hearing Department was pleased to issue notice. And notice was issued. And steps were taken. Now, my lord, the only problem is that the petitioner retired on 31st January.
No,
22.
let me see this impugned, the earlier order
My lord, impugned order.
in 5612 of 2021.
Yes, my lord. Now, at page 20, is the order issued by the director on 30th June 21. This order was already challenged and we got the stay order also in another repetition. Same order is repeated, Lordship kindly see then another order at page 6 October 21. While I was in service, this was also order also was interfered by the Honorable High Court. But when the petitioner retired on January 30, 22, petitions became infectious. Now after retirement, Lordship, at the behest of the private respondent number 4, this page 21, my lord, this was issued without allowing me to examine the cross-examine the evidence and without allowing me to file the written statement. My lord, the order was issued, order was passed by the government. Page 21, my lord. My lord, kindly see, same thing is repeated. My lord, kindly see. There are middle person, already this office letter dated 36/21, an inquiry team was considered to inquire into the matter relating to public complaint against principal in charge of Bedara Ansalik Senior Secondary School. Kandu district and request to submit report within 15 days. Charges are this, not convening the meeting of the SLDC during her tenure, not maintaining records relating to accounts matter of the institution, operating bank account single-handedly.
No, show me so the 6/10,
My lord,
2021,
2021.
that is at page 21. This has been stayed,
It has been stayed by the High Court.
has been stayed by the, then?
Yes, then while the case was pending, she retired.
Huh.
Retired from service. And after retirement, my lord, same thing has been repeated by the government. Now the pension is not released. I have retired, my lord, on it is more than nearly 3 years, 4 years.
Yes, what is the thing?
But there has to be a challenge with regard to that the pension has not been released. Now, your lordship will kindly see what is the challenge in this repetition. The 3 orders, that is 1/6/10/2021, whereby, my lord, the petitioner was relieved from the in charge and the inspector of school was given the charge. 6/10/2021, and then
6/10/2021.
6/10/2021 is a order constituting an inquiry committee to inquire into the allegations. Sorry, first page 20, my lord. Page 20 of the repetition.
25.
Page 20, 20.
20, yes.
This is one of the impugned order which is challenged. In partial modification of this office earlier dated so and so, the following officers and the officials of the director are hereby appointed as the inquiry officer and presenting officer to inquire into the matter relating to the public complaint against so and so so and so in charge principal. These are the officers who were appointed. Now subsequent thereafter, 6/10/2020, page 21.
Yes.
6/10/2021. Based on that inquiry, my lord, the whereas representation that has been received from president and so as well as certain numbers of public of Bezara area, Kamrup district, wherein they have submitted certain complaints against Sandhyarani Devi, principal in charge of the institution. Whereas this office, by later dated 36, an inquiry team was constituted to inquire into the matter relating to public complaint against the principal in charge and request to submit the report within 15 days. The charges are, these are the charges. Now lordship will come to page 22. Second paragraph, last second paragraph, on the facts and circumstances and the interest of the public service, so and so in charge is hereby relieved from the charge of principal of the institution in the interest of the public service. So and so inspector of school is hereby allowed to hold the charge of principal of
So,
the.
so he is retired now.
Now retired.
So
This
that,
was-
so this is,
This-
hardly,
Yes, this will not, this is not going to affect the prisoner, even if it is statement.
and then third,
Now the
or
third
any other challenge made?
and the so-called notice that has been issued, that your lordship will find the so-called notice dated 14/8/2024,
Page 31.
page 31. So the interim order, even if it is passed to these two orders, the earlier two orders, that would make no difference. my lord.
No, so you
Except
see,
the so-called,
one is only with regard to an inquiry.
one was
With
regard
the
to appointing
constitution of an inquiry committee.
Yes.
Now this inquiry committee has done its job.
that
So
has
that's
done-
finished.
Ah.
Miss-
And
Number two
the
is
order-
the 6/10/2021 is also infractious because
because of
he is retired.
retired.
So number three is he is challenging a show cause notice. That's all. That's it. How can you challenge a show cause notice?
That's all, lordship, kindly the show cause notice.
Huh?
What they have written. This is repeated, kindly see, my lord. Number one, that, while you were in service and serving as a principal in charge of Bedara Secondary School, Kamrup district, you were found involved in not maintaining accounts of the institution, including cash book, operating the bank account single-handedly, collecting admission fees from the students of class 9, and final pension papers of the retired principal. You are therefore charged with involvement in misappropriation of fund, relating to power of in accordance to
It's a psychiatrist.
now, lordship, just a minute.
Hmm.
This is repeated in this has been earlier also issued. Lordship, and this is the other part with the High Court. This has been repeated earlier, that same thing of
Yeah.
page 21 is repeated, page 21. Annexure A1. The order was issued on 6th October 21. This is the same thing repeated, lordship. And this is charges.
No.
Yes, yes,
You see, Mr. Counsel, there
No,
are
Father, kindly see, charges are 1, 2, 3, 4, 5. Now, kindly see the order of the High Court, madam. At page 25. Page 25, relevant portion I will read. This order was passed on 27 October 21, madam. Madam, relevant portion will be at,
Mr. Counsel, please understand one thing.
my lord,
It's a two-way traffic, this court.
Madam.
You have got to hear me also.
my lord,
So please, you see this 6/10/21
my lord.
speaks of the inspector of school being allowed to hold the charge of principal.
Madam.
That had been stated. Now, you have retired,
Repeat.
you cannot hold the charge of principal.
No, I cannot.
So that issue is gone.
Gone.
Then where is the question of, that has been stayed earlier.
My lord.
Now there's no question of stay, because even if we stay, you cannot hold the charge of principal.
No,
You've
my-
got no locus standi.
My lord, you lordship is right. But
Then,
the problem is that by taking the shelter of this so-called notice, which is illegally what issued, and my pension is held down.
But that is a different issue.
No,
That's a
but-
different
but-
issue.
my
But
lord-
can you challenge a show cause notice? That is the issue.
My lord, yes, I can challenge.
Show me
because-
the, show
my
me
lord,
the law.
kindly see the punishment that is
No,
after retirement, lordship. After retirement,
judgment today.
rule 21 may be seen, my lord.
Our Mazumdar said.
My lord. Rule 21 may be seen, my lord. Whether after retirement, the government can issue a show cause notice. Rule 21, my lord.
No, you see, Mr. Counsel,
For you, lordship,
a show cause notice
yes, ma'am.
does not in any manner prejudice you.
No, no, they have told me that I am involved.
Correct.
Without
That is only an
No,
allegation.
no,
A
they
show
have
cause
only-
notice is only an
What the show
allegation.
cause notice is issued on the finding of the inquiry, expert inquiry report.
Inquiry, now you see this inquiry,
Kindly read, let me read, my lord. To page annexure B.
you're not understanding the
No,
issue.
no, lordship, just a minute, if time does not permit,
Okay.
maybe taken up.
No, no, there's not a question of, I understand fully.
My lord will kindly see, my lord. In exercise, page 31, the powers contemplated by notification dated 5th December 1967. What is the revision? The department, the undersigned hereby asks you to show cause under Rule 9 of the Assam Services Disciplinary Rule. Why in any of the penalties shall not be imposed? That they cannot done. Rule 9 may be seen, my lord.
So please answer, have you answered the
No,
show
no.
cause notice?
But so called under Rule 7, they can proceed. They wanted to impose punishment.
You please answer, let them take a decision, then only you come and challenge. We don't,
And
whatever you are saying today, before this court,
my lord.
you say it in a reply to the show cause. You say whatever submissions you make today to
No,
that.
no, my lord, I have issued a letter candidacy, my lord, so called to the so called notice candidacy. Letter of my letter of my lord. What they are doing, my lord, the government, with the insistence of a letter may be candidacy. Before that, at page 48 may be seen regarding involvement of financial liability. Page 48. My lord, a letter issued by the principal in charge of the present school, issued to certify that simulation, Dharani Devi, in charge principal, Vedara Anchalik College, now Vedara Anchalik Secondary School, District Kamrup, retired from service on 31st January 22. She has no any financial liabilities against the institution, Vedara Anchalik Secondary School. I have no liability at all. And now, lordship, another paper, kindly see.
Mr. R.C. Saikya,
My lord.
learned counsel for the petitioner, who submits that the petitioner the petitioner retired as
And the principal himself.
the principal in charge of the Bezira Anchalik Senior Secondary School on 31/1/2022. Pusta. The petitioner's grievance is that
My lord, she retired on 31st January.
31/1/2022.
Yes.
The petitioner's grievance is that the respondent number 2
That's one number 4, what she insisted. 4. Yes,
had
this order.
issued an order dated 6/10/2021 earlier, by which the inspector of schools, KDC, Kamrup (R) had been allowed to hold the charge of principal of the school in addition to his normal duties until further orders. The said order dated 6/10/2021 was put to challenge in WPC
5612. my lord. At page 25.
5612, SAC 2021. And this court by order dated 27/10/2021 state the impugned order dated 6/10/2021. What has happened to this case? It is still,
Page 30.
has it pending or finished?
It has
Pusta.
page 30, my lord.
Okay.
Finish correct.
Pusta.
30, my lord, that.
Next
while-
para.
While she there,
As the petitioner had retired on 31/1/2022, this court dismissed WPC 5612 of 2021 as infructuous by order dated
Yes.
T1/2024. Pusta. Next para. The petitioner's counsel has again approached this court in view of the the show cause notice dated
14/8/2024.
14/8/2024 issued to the petition. Where is that page?
Page 31.
Whereby issued to the petitioner under Rule 9 of the Assam Services Bracket Discipline and Appeal Rules 1964. As to why the penalties under Rule 21 of the Assam Services Bracket Pension Bracket Close Rules 1969 should not be inflicted upon him on the following charges and statements of allegations attached with the show cause notice. The charges against the petitioner in the show cause notice are as follows. It is very unclear.
my lord. My lord, one submission, my lord, left over, kindly, my lord, see the.
It's as follows, it's as follows. Page 31, okay. Here, the petitioners also have been asked to submit his written statement of defense within 7 days from the date of the communication. Did you submit your written statement of defense?
No, we have written a letter that they did not punish me. I have said in the letter that they did not punish me, the statement of allegations and inquiry report.
Statement of allegation is page
Huh?
32. Statement of allegation is page 32.
No, they did not, I have written the letter that the statement that they did not punish me, the inquiry report, my lord.
Inquiry report, Mr. Counsel, will come only after the proceedings are initiated.
No, they
So
said that the
possibly
inquiry was,
my senior is
my
correct,
lord,
my lord.
they say.
Page
your-
33,
my
there
lord,
is a
they
letter by.
stated that the inquiry is conduct, expert inquiry is already, inquiry is
No,
already
no, no,
performed.
no.
Inquiry report, my lord.
Inquiry report. This inquiry report you submit to him.
Yes, that is a list of documents, my lord.
Yes, you have to give it to him.
Yes. Lordship will
They
indicate. that.
should give me, my lord.
I will tell them to give
Yes,
it.
sir, Lordship will
And
indicate.
nextly, my lord, only one second. Under the rule, my lord, under Rule 21, without the sanction of the governor, after retirement of a person, they cannot start the departmental proceedings.
That all those submissions you make in your reply will give you time to file your reply.
My lord.
You make your reply, not here.
Yes.
Okay.
Yeah, okay, my lord. That will be sufficient.
Next, the petitioner's counsel submits that the petitioner thereafter submitted a letter dated 27/8/2024 to the Director and Disciplinary Authority, the Director of Secondary Education and Disciplinary Authority, requesting him to give the petitioner the inquiry report submitted by the inquiry team pursuant to the DSC's order number PC/JC/03/2001/PT-1/85 dated 30/6/2021, which was in the list of documents in the statement of allegation submitted to the petition. However, the said inquiry report has not been furnished to the petitioner till date. Full stop. Next paragraph. No, next paragraph. Full stop. The petitioner's counsel submits that if the said inquiry report, which is reflected in the statement of allegations, is furnished to the petitioner, he can make a proper reply in his defense to the show cause notice dated 14/8/2024.
Yes.
Next paragraph. Mr. B. Kaushik, the learned counsel for the Secondary Education Department, submits that the inquiry report, which is reflected in the statement of allegations, shall be furnished to the petitioner within
1 week
within 1 week
from the date of receipt of this certificate.
from the date of receipt of a copy of this order. Full stop. Next paragraph. In view of the submissions made by the counsel for the parties, this court is of the view that the issue need not detain this court any longer. Accordingly, the Director of Secondary Education and the disciplinary authority, just say Director of Secondary Education shall furnish a copy of the inquiry report to the petitioner that has been reflected in the statement of allegations made. This is a statement of allegations annexed to the show cause notice dated 14/8/2024. The same should be furnished to the petitioner within a period of 1 week from the date of receipt of a copy of this order. Full stop. Thereafter, the petitioner should be given 1 week's time to make a reply to the show cause notice dated 14/8/2024 with effect from the date of receipt of the inquiry report.
Yes.
That's all. The writ petition is accordingly disposed of.
Can you lordship give me some relief regarding pension?
No, not now. You have got to give your reply first, not before that.
Pension, provisional pension may be given.
You see, why you are going to make them wise before if we start anything. We have got to go into Rule 21. Then.
Yes, Rule 21.
Yeah, Rule 21. If I start going into Rule 21, they will wisen up and they will do the necessary thing. Why you want to show everything to them?
Okay, lordship. Okay, ma'am. Very nice.
In view of the no, you can give it back. In view of the order passed in the main case, the I is also disposed of accordingly.
The requisition disposed of. Obliged, lordship. The great relief.
39.
May I please, Your Lordship?
Yes.
Here they are relying on page 38. They are praying to comply this direction passed by the district. They are relying on page 38. They have kindly see page 38.
Yeah.
Both the parties are summoned. After hearing both the sides, it was advised to convene a meeting of the SMC by the headmaster. Presence of every member must be obtained. At that meeting, complainant may propose no confidence motion against the president. Well, here, he is praying for direction from this honorable court to direct the headmaster to convene the meeting. Well, here, notice has already served to the respondents now.
So why aren't you enforcing it?
I'm not enforcing, ma'am. I'm just placing the case.
No, I'm saying why aren't you see when they want a no confidence motion. The thing has been sent to them or what? I You see, the direction has been passed by you, by the DEO,
My lordship.
to the headmaster,
My lordship.
to convene a meeting.
My lord. Yes.
Now, why aren't you enforcing that?
I'm not.
What do you mean? You should enforce. It is your direction. What I'm saying is,
But
huh?
my lord, here, my lord, he is praying for to convene the meeting by the headmaster. Yes. But the headmaster is a party here. Well, he has not appeared before this honorable till that man. Lordship may dispose of this matter, directing the headmaster to convene.
You're not understanding. What I'm saying is,
My lord, sorry.
supposing you now assuming you're the DEO, you're the DEO.
Yes.
You have told the
My
headmaster,
lord.
convene a meeting
My lord.
for that no confidence vote.
lord.
So headmaster is not doing it.
My lord, I can.
So why aren't you, the DEO, telling the headmaster
My
do it? That's
okay,
what I'm saying. Why aren't you enforcing? Not you as a lawyer.
I can.
You as the DEO.
My lord, I can.
Why aren't you doing it?
Well,
That is what I'm saying.
Well,
I mean, why should you see? Why should you come to me?
My lord,
You have got enough power.
I can. My lord.
You can do it.
My
That's what I'm saying. Why aren't
lord.
you doing it? Otherwise, I
Lordship,
can direct, no doubt.
My lord, I'll do. My lord.
Let us see the letter by them. Page. The letter DO letter 2008 for 24.
Lordship, page number 39, lordship.
39.
Original one, lordship. And lordship, 37, type copy, lordship.
37.
Yes, lordship. And order, lordship, operative part is 38, lordship. What is lordship? That is type copy. What is lordship? 38, lordship.
Yeah?
Page number 38, lordship.
38.
Yes.
Yes.
Type copy.
Both the parties are summoned.
But I have shown my lord. That is type copy, my lord. Type
Yeah.
copy.
But who has said both the parties are summoned? Whose note is this?
This is my lord, DEO, my lord. And
DEO.
DEO, lordship. District Elementary Education Officer. lordship.
So then you have to
Yes,
enforce
my
it.
lord. I'll ask the DEO to.
You have to ask the DO, or should I direct and
My lord.
dispose of this writ petition?
I'll. Our limited prayer in this writ petition, lordship, kindly directed the headmaster, lordship, to convene a meeting of no confidence motion, lordship. This is our limited prayer, lordship.
Okay, in terms of which provision of law?
Lordship. Lordship, rules 13, 4 with rules 13. Lordship, page number 258, lordship. New book, lordship. Rules 13 within bracket 4, lordship, and Roman 3, lordship, and Roman 5 and 6, lordship, and rule 13 within bracket 5.
Just a
lordship.
minute, just 2 minutes. Rule 13, 4.
4, lordship, within bracket 3.
No,
5,
3 will not come.
lordship, 5, lordship,
You want no confidence motion. No, so where is that?
and 6, lordship. 6, the district elementary education officer or the authorized by him, the deputy inspector of schools, block elementary education officer, concerned shall have the authority to issue direction for holding the meeting of the SMC and when required for lordship. But after directing the lordship holding the meeting,
Which provision are you reading once more?
lordship, rule 13 within bracket 4,
Ah.
Roman 6, lordship.
Roman 6.
Yes, lordship. Lordship 5 will come, lordship. Lordship, the president shall call a special meeting of the SMC if more than 50% of members of SMC make requisition for it.
So this is not here. You're not 50%.
A lordship, where 50%, above 50%, lordship.
SMC, this is the, if the, of the SMC, if more than 50%, so you're more than 50% petitioners.
Yes, lordship.
Yeah, you're more than 50%.
But the majority person, lordship.
Huh?
Yes, lordship.
And where is the no confidence motion?
Lordship, no confidence motion is lordship.
Huh?
That has not been taken as per the
Lordship,
what I'm understanding, my lord, as per the order of the DEO, my lord. Here, my lord, presence every member must be obtained at that meeting. Complainant may propose no confidence motion, my lord.
Correct. Under what provision? There must be a
My
provision.
lord, the removal of the president and member of the SMC. Here, my lord, kindly see next page.
Huh?
Next page 59.
Yes, yes.
Removal of the president. A person shall not be qualified to be a president, vice president, or member of the SMC and can be removed by the SMC through a resolution signed by the at least two-third member present in the.
Page 59?
259. Next, this. Roman, this,
Huh?
section, 13.5.
13.5?
My.
Huh?
Roman 2,
Roman 2.
A person shall not be qualified to be president, vice president, or member of the SMC and can be removed by the SMC through a resolution signed by at least two-third member present in the meeting. At the meeting, which should not be less than or equal to 50% of the total member of the committee, or by the district elementary reason after satisfying himself herself to the fact so. And
Yes, so why do you want to remove him? Does he come under any of this? Five,
Lordship.
two? Yes, which one?
Lordship, we have filed various representation before the BO as well as DO Lordship. For that Lordship, the president not conducting the SMC meeting Lordship. We have filed various representation Lordship.
Not conducting SMC meeting.
Yes, sir, not conducting the SMC Lordship.
But that is not stated here.
Yes, Lordship, kindly come to Lordship, Annex 2 Lordship.
I'm not talking about annexure 2, I'm talking about the law in the rules, 2011 rules.
Yes,
Violation
Lordship.
of what?
11 rules Lordship, 13 within bracket 4, Lordship, within bracket Roman 5 Lordship.
Yeah.
The president shall call a special meeting Lordship of SMC if more than 50% of members
But
of
for
SMC
removal. I'm talking about removal. That is only for meeting.
removal for Lordship, she is found guilty for the misconduct of negligence of duty Lordship. He is not conducting the SMC. This is the negligence of duty Lordship.
Okay.
This is the negligence of duty.
Negligence. Okay. So we'll dispose it off.
Yes, Lordship.
All right. Heard Mr. A. Alim Sheikh.
Yes, Lordship.
Learned counsel for the petitioners. And Mr. P.K. Bora for the
Elementary Education Department.
Elementary Education Department. The petitioners, then you take the last order, you take the second para. Second and third also, huh? Right. So who is the respondent, the main respondent?
Lordship, head in this petition, main respondent Lordship, respondent 6, BO Lordship, and 8 headmaster Lordship.
No. Who is this respondent number 9?
9 is the Lordship,
President.
President of SMC Lordship.
Huh?
President of SMC
President.
Lordship.
Number 10? Who is 10, 11, 12, 13?
Lordship, other member Lordship.
Other members?
Yes, Lordship.
And you are also members?
Yes, Lordship.
Here, my lord.
Where the majority, where the
8 and 9, my lord. You think cast upon 8 and 9 to conduct the meeting.
8 and 9
My
to hold the SMC.
My lord.
Okay. Anyway, so how many members are there altogether?
Lordship, 12 member Lordship.
12 members.
Parents member.
Huh?
Parents, guardian and parents, 12 member Lordship.
12 members.
Yes,
So
another person also appointed.
read petitioners are how much? 7?
7 members Lordship.
Read petitioners 7 and the other side is 5.
Yes, Lordship.
Other side is 5. So altogether with the president 12.
Yes,
With the president, there are 12 members.
yes, Lordship.
Right. The petitioners council submits that the respondent number 9, who is the president of the SMC, School Management Committee, bracket SMC, has failed to conduct any meeting
Yes, Lordship.
till today. Is
Till
it?
today, Lordship.
Till today.
Yes, Lordship.
When were you constituted? When were you formed? Which date?
Oh, Lordship. It is formed on Lordship. It is formed, Lordship, date was 22/11/2023, Lordship.
22/11/23. So from that time till today, no meeting.
That time, Lordship, from
When was the last meeting?
last meeting was Lordship, 28/6/2024. But Lordship, President was not present in this meeting, Lordship.
Who was not present? President.
28/6/2024, Lordship.
President was not present.
No.
And so after this, no meeting.
Yes, Lordship.
Prior to that, there was meeting.
Yes, Lordship.
Did he attend?
Prior that, Lordship, after requesting of to BO convene a meeting, after that one meeting also Lordship conducted.
How many meetings conducted altogether?
Altogether, Lordship, total is not in.
Okay, forget it. Right. The petitioners council submits that the school management committee bracket SMC was constituted on 22/11/23. And the last meeting of the SMC was held on 28/6/2024. However, the respondent number 9, who was the president of the SMC, did not attend the SMC meeting held on 28/6/2024. Besides the above, the respondent number 9 has failed to conduct, has failed to convene any meeting beyond, any SMC meeting beyond 28/6/2024. The petitioners council submits that as the submits that a direction should be issued to the respondent number 8 and 9. 8 and 9. 8 is school management committees. 8 and 9.
Lordship, 6 also, Lordship.
6, 8 and 9.
Yes, Lord.
6, 8 and 9. To convene a special meeting of the SMC in terms of
What are dated?
in terms of rule 13 bracket 4 bracket Roman 5 small and Roman 6 small.
Yes.
Of the Assam right of child or children?
Children, Lordship.
Assam right of children to free and compulsory education. Rules 2011, hereinafter referred to as the 2011 rule. He submits that he further submits that a person that he further submits that a president of an SMC can be removed by the SMC through a resolution signed by at least 2/3 members present in the meeting of the committee, which should not be less than or equal to 50% of the total members of the committee, or by the DEO after satisfying himself of the facts through an inquiry. if the president is found guilty of misconduct or negligence of duty. In terms of Rule 13 bracket 5 bracket Roman 2 small of the 2011 Act.
As well as 4 also, Lordship. Roman 4.
The 2 and 4, huh? And Roman 4. More. That's all. Full stop. Mr. B. Kaushik, no, Mr. P.K. Bora, the learned counsel for the Elementary Education Department, submits that the writ petition can be disposed of by directing the
District Elementary Education Officer.
the respondents number 4, 8 and 9 to
6,
no,
8 and 9.
4, 6, 8 and 9
Yes.
to convene a SMC meeting wherein the petitioners can propose a no confidence motion against the president of the SMC. On considering the fact that no one appears on behalf of the president of the SMC, though notice has been served upon him, is deemed to be served upon him, this court is of the view that the writ petition can be disposed of as the issue to be decided as it lies in a very narrow compass. No, as there is nothing to be decided here. As the petitioners herein make up 7 out of 12 of the school managing members of the school management SMC, and as the district elementary education officer Dubri had directed the respondent number 8 to convene a meeting of the SMC on 20/08/2024, which has not been exceeded to by the respondent number 8. This court is of the view that the respondent number 8 cannot shirk his duty, SHIRK, by not convening a meeting as directed by the district elementary education officer. Accordingly, the respondents number 4, 6, 8 and 9 are directed to ensure that SMC is conducted and held on or before sometime will be on or before. Hey, that Bihu time so no one will be there.
After Bihu, madam. After 30th of the trip.
On or before 30/04/2025. After giving adequate notice to all the SMC members. The issue of whether, the grievance of the petitioners will also be looked into and considered on the said date and in the said meeting. The writ petition is accordingly disposed of. Huh?
So my small prayer, Lordship, can meeting, Lordship, premises in the office of BO, Lordship.
Will it be office will be okay?
Office of the block elementary
It will be held in the school, madam.
We can tell the officer to be present.
Yes.
The concerned BO
Yes, Lordship.
is also directed to. But then that will send the wrong message every time or there will be a problem.
As per law, madam.
Huh?
As per law. Per rules, madam. On our meeting, we conduct as per rules.
And the meeting should be also be conducted as per rules, as per the 2011.
Yes.
The writ petition is accordingly disposed of.
Yes. Lordship.
Yeah. No one appears for the petition on call. As per office note dated 4/4/25. Notice had been sent to the respondent number 6 on 25/3/25. Though dusty notice was made ready, no one has appeared, no one has turned up to collect the same. In spite of providing information over phone to the council that the said copy of the notice was kept ready on the record of the Part 2 file. It appears that the petitioner is not interested in pursuing the matter. However, in the interest of justice, one last chance is provided to the petitioner to appear. Lives the matter on 30.
May I please motion? In page number 15 of my petition.
50.
15, paragraph number 17. The fourth paragraph, I want to read Lordship with your permission. As per statement of DEO, Bhattadraba made before the DE Assam during hearing of the matter, 1 bigha land was registered on 23/7/1992 in the name of the school headed by the respondent number 9. But as per particulars submitted by the respondent number 9 for provincialization of the school headed by respondent number 9, 1 bigha land was registered in the name of the school of respondent number 9 by sale deed dated 16/6/1998. Now, Lordship, I'm only placing before your Lordship the facts. The thing is that about 250 families live there in a small pocket in this Ahomgaon village. Approximately 700 voters are there of tribal community. The school was set up with the name Dakhin Ahomgaon Janajati Balika School for the girls. It was running accordingly, but during the release of two sets of next page, that is page number 1616, second paragraph. On the other hand, the above named three authorities released rupees 49,500 and 16,500 to the respondent number 9, who claimed and introduced himself before the authorities as headmaster of Dakhin Ahomgaon Janajati LP School. It does not contain the word Balika. It's supposed to be for Balika, and not as headmaster of Dakhin Ahomgaon Janajati Balika LP School. During that release of amount, the word Balika was omitted. As how it was omitted, it is unknown to me. So later on, they got provincialized with the word Balika, but during the release of the money, the Balika word was not there. So what happened? We faced the loss because somehow in this entanglement, our school, which was for the girls, Balika means girls. So this girls' school was converted into co-education school for the time being. Then again it gained Balika, and now we are outside the school. These two persons have come in between long after our school was there. So the findings of the director is not supported by the documents that they had produced before the director. And one more thing, my learned friend has rightly said that during the 1992, the petitioner number 2 was minor or not. I don't know how the age is. That is not the fact. The school was provincialized in 2007 when I was a minor. That is the case. It is not about when long back I was a minor or not, I was born or not. It is not regarding that. The thing is that the school existed much more before I was there, or we both, two petitioners are there. So before us. So that is the entire case, that it belonged to a tribal community of around 250 families, only about the future of the girls. That is the only case. And your lordship was, you already know that they are in earlier round of litigation, this was, your lordship was kind to pass the order, and we have appeared before the director, and this submission regarding the drawing of money, this was placed in earlier hearing, an order passed by the Honorable Court 25/11/2020. There is the order. They have not replied yet.
Yes, what is this?
The basic challenge in this repetition is the speaking order that is passed by the director pursuant to the direction of this honorable court, page 63. Lordship will kindly see the finding. Page 63.
Yes.
From the statement of the person present and relevant records examined, it is found that Dakshin Ahomgaon Janajatiya Balika LP School was established in the year 1990 by the people of that locality. The respondent number 9, Abdul Rafiq, was appointed as head teacher of Dakshin Ahomgaon Janajati Balika LP School by SMC resolution in its meeting dated 13/3/2003, and Farida Khatun was appointed as assistant teacher by SMC of the said school by resolution dated 15/10/2001. The proceeding book of the SMC submitted by Abdul Rafiq, head teacher of the said school, unveils the sitting of the SMC from 1990 to 2017, countersigned by the BEO Botodropa by the ADC in some of the pages. The BEO Botodropa stated that there is 1 bigha land in the name of the school registered on 23/7/1992. The particulars for provincialization of services of the said school were submitted by the head teacher Mohammad Rafiq to the DEO Nagaon, and the same were submitted to the DE Assam along with the recommendation by the DLSC Nagaon. Thereafter, the DA Assam sent the same to the government and the government sanctioned post, and this office issued order of provincialization. Regarding the claim of the petitioners, Sri Amrit Deuri, stated to be the president of SMC of Dakshin Ahomgaon Janajati Balika LP School, states that the proceeding book of SMC have been lost. He also submitted one photocopy of the FIR lodged in the police station regarding the matter. On the other hand, Tirtha Kumar Deuri, the petitioner, who claims himself to be a genuine headmaster of the school, is completely ignorant about the loss or lodging of the FIR and promises to submit the proceedings book later on, which he failed. One proceeding book is submitted showing proceeding from 2013 to 2016. Sri Tirtha Deuri passed HSLC examination in 2007. In HSLC's first certificate submitted by him, his date of birth is seen as 6/7/1991. As stated by the petitioner Tirtha Deuri, he was appointed in the year 2007 when he was about 16 years old, when he does not fulfill the eligibility criteria for appointment as laid down by the government. The post of Dakshin Ahomgaon Janajatiya Balika LP School were provincialized in the year 2013, and the petitioner Tirtha Deuri and Muhammad Inamul Haq approached the Honorable High Court in the year 2015. That is about 2 years after the provincialization of service of the teachers of the school, which is a surprising matter. The DEO Nagaon, the Deputy Inspector of School Nagaon, and the BEO Botodropa stated that no complaint has been received against the school by their officers as claimed by the petitioner. Again, as stated by them, the dice code number so-and-so has been allotted to the school headed by the respondent number 9 and 10. In view of the facts and survey, it is seen that the respondent Muhammad Abdul Rafiq and Farida Khatun were appointed by the SMC of Dakshin Ahomgaon Janajati LP School, and subsequently their posts were provincialized on the basis of the DO's report in the year 2013.
On the other hand, no convincing ground could be found to establish genuinity of the claim of the petitioner, says so and so. Hence, the claim of the petitioner cannot be considered and thus rejected. So,
This
Malad,
is
this
issued in compliance with the Honorable High Court's order dated
6 to 2015.
Okay. This is a question of fact.
This is a question of fact.
Then can we go into that?
And more so importantly, my lord, I think, my lord, in terms of the full bench decision, my lord, because this is a dispute which is prior to the provincialization regarding the existence of the petitioner or the private respondent. So that necessarily has to be go to the educational tribunal, my lord, under the constituted in that district.
So when we talk of provincialization, it's basically the provincialization of the teacher only.
Teacher.
No,
No, under the 2011 Act, it was the school which was provincialized. Now, 2017 Act, we provincialize the services of the teachers, and therefore the act is called reorganization of the institution.
Otherwise, then the school remains the same. Only the teachers are.
Teachers are provincialized under the 2017 Act. When the teachers are provincialized, taken for provincialized, one school is taken as a base school. So the teachers of that provincialized school, they merges with the base school. It may be the present provincialized school.
Does the base school become a government school?
The base school become the provincialized school. The base school can be either an existing provincialized school or one of the provincialized schools.
One of the schools to be provincialized.
Yes, which has got all the infrastructure.
That is what there's the way the words are used. Sometimes very confused. 2011 Act was basically for provincialization of the school.
Schools, along with the teachers.
But here it's only provincialization of the teachers.
And therefore the preamble of that act also says it's reorganization of the institutions. Now, the moment that school is provincialized, if the teachers are merged with the base school, that school has to hand over the land and building to the government.
The base school.
No,
the other school.
The other school.
Yeah, that's
Because
to hand over.
everybody, the student, teachers, everybody will go and join the base school.
But the owner of the base, the land of the base, the other school, is going to be at a loss.
Because the owners are basically they have gifted the formation of that school at that point.
They are the teachers of that school.
Either it is an SMC's land, school managing committee's land, or the people of the locality. Usually the people they donated for establishment of the school. There are some cases also we have come across where there was a condition in the gift deed that if this land is not used for the purpose of school, then it has to go back. Now, because of Section 5, the land has to go to the government.
Yes, what to do, Mr. Counsel? Here is a disputed question of fact. It's on the basis of a decision of this court. The only way you go to the tribunal.
Instead of,
I'm
just saying that, can the director look into it afresh with written?
It has already been done. You have to challenge it now. That's a review. That unless you show me, you have got to show me with material that this is wrong.
And the challenge is not.
It's not on the basis of words. You have got to show me with basis of documents.
And the challenge is not with regard to the decision-making process, the decision.
Yes. The decision. How is the decision wrong? You have got to show me. Not with your own words. That is the problem.
Wrong because of they have not taken into consideration all the facts and circumstances as well as material records, because there are two cell dates. One is from 1922 and 1992 and like this one.
1992.
Yes, Lordship.
Can this court go into those issues?
No, because what they shown earlier, before the director, they have shown a different cell date.
So the problem is, I don't know about that.
Yes, Lordship.
You can file a review against with the director. I don't know. But I don't know. Otherwise, the best way is all those documents and all the things that you think you haven't produced, you go to the tribunal.
Well, I think that the tribunal is the better recourse because he will also be able to give evidence.
Yes, he'll be able to give evidence. I think evidence is required.
Evidence would be required, Malad, because he will have to prove his existence at that point of time.
So the Dias code was allotted to you in 2008-9,
Yes, what?
huh? Dias code was allotted to whom?
According to our affidavit, my lord, the dice code in the name of Dokhin Ahomgao Janajati LP School, there were three teachers' names. So, Anil Chandra Bordoloi.
But then
Iqbal Hussain,
that word
yes.
Balika has to be there, no?
Yes.
The Balika is not there.
And the other dice code of Balika, that also doesn't show the name of the petitioner. my lord. It shows Farida Khatun, Mamuni Begum, and Abdul Rafiq. Abdul Rafiq and Farida is the one who has been provincialized against Balika. Para 5 of our affidavit are the facts which possibly you'll have to control.
Yes.
Because we say in our record, we do not, there is no existence of him.
I leave it to your.
You can withdraw with liberty to go to the tribunal.
Worship, the thing is, I'm not submitting on part of this case, but because this was used to be my senior used to appear here. He's no longer, he has passed away.
Okay.
So the thing
Who's
is.
your senior?
So, Sharif. So now the thing is, I leave it to your lordship wisdom, keeping into consideration the small cluster of people living there.
No, I'm not going into emotions.
No, lordship, even if I get some favorable order, it has to be based on certain records. I'm not asking anything beyond that.
Okay, which page were you talking about? I've got no time. I've got a meeting. I've got a meeting. I was going to dispose of, but what?
But I was suggesting it's better to go to tribunal.
I know it's better for your clients also.
Here he will not get an adjudication. And
Out
lordship
there, it
cannot
will be
do all this.
the end of the road for them. At least you can go there.
Based on the materials that is available before your lordship cannot answer this. Because we have said something that there is no record at all. Now he'll have to place those record.
And maybe to your lordship wisdom.
No, not my wisdom. Yeah, you think of your client's interests. That's all. So what we can do if you want, we can adjourn the matter. You talk to your clients whether you want to go to there. Otherwise, then we'll dispose it over them. Okay. Right. Heard the counsel for the parties. The issues raised by the petition against the impugned order dated
12 to 2017. 12th of February 2017.
This case had come to me also.
Yes, earlier lordship.
2015, I had passed the order.
We have an exit order.
Where is it? The impugned order?
Page 63.
What have I said? I had the cause for the party. The issue raised in this petition pertains to whether the petitioner's school should have been provincialized as against the school of the respondent number 9.
9, 10, 11 will come because the 9, although we implemented number 9, but he again came up as respondent number 11. but
Against the school of the respondent number 9. Which has been, full stop. The Director, Elementary Education had held that there was no convincing ground to establish the genuineness of the claim of the petitioners. and as such, their claim was rejected. The same was done in compliance with the order dated 6/2/2015, passed in WPC 2561 of 2015. The issue raised by the petitioner pertains to disputed questions of fact, which, in the view of this court, may not be possible to be adjudicated in a writ form. The petitioner's counsel submits that he will obtain instructions as to whether the petitioners would like to withdraw the writ petition with liberty to approach the educational tribunal. This is the matter. After 4 weeks. When do you on a date? This is the matter, no, this is the matter on 8th May.
Briefly on.